Gullible minion, do-pa-dee-doo. I've got a germ tail just for you. Gullible minion, do-pa-dee-dee. If you are wise, you will listen to me.
What do you get when a germ starts to spread?
Filling up minions with lies in their heads.
Spreading defamation all over the site.
Dodging the rules while avoiding the light.
He's untouchable.
Or so he thinks.
Gullible minion, do-pa-dee-doo.
I've got a germ tail just for you.
Gullible minion, do-pa-dee-dee.
If you are wise, you will listen to me.
What do you get for a suit gone to trash?
A judge who says, drop that ridiculous hash.
8 people sued just to make a new clip.
While the germ lets a dismissal slip. With prejudice!
Don't come back! Gullible minion, do-pa-dee-doo.
The germ is just making a sucker of you.
You will live in legal bliss.
Like a lawsuit that just got dismissed.
Hey, everybody. How you doing? Happy Thursday. What is going on? Oh, my goodness. What a day. What a day. Let's see. Hi. Hello. Hello. Sorry I'm a little late. I actually didn't set my thumbnail up in time, but I wanted to give enough time for everyone to get notified. So I'm waiting to see what's going on with Robbie. I think he was coming on. Hi, Tease Gems. Hi, Bonnie. Hi, Tammy B. Hello. Y'all like that Minions? Do-ba-dee-doo. I set it up one night for it to be the intro, and I forgot to remove it, so it keeps popping up. Did you get my email? Yes, I did, Tim. Thank you. Hi, Megan. Hi, Crimson. My God, it is so hot right now. I'm muggy. Hold on. Okay. Guys, Kendra just did a little update. Kendra's doing a little better. So thank you all for the prayers. Keep them coming. I saw Ray Bone Crusher was here. How you doing, Ray? Hello, there you are. Hey, John Cook. I could use your prayer that looks my. Oh, I'm so sorry, Martha. Prayers up to you and your family. My condolences. I'm so sorry to hear that. You like the Minion song? I know. I love the Oompa Loompas. Oh my goodness. Hey, cat lady, Scappy girl, Tammy B, Bonnie, Tricky Chee. My nasal passages. My nose feels like stuffed up. Oh, yo, Rich, what's going on? Oh my gosh. Yeah, I don't know if do I sound nasally? So it was kind of a chill day today. I definitely caught up on a lot of sleep last night. Yeah, I'm so sorry. Hi, Linda. Let's see. Gotta play Shut Up, John Cobbs tonight. Possibly. You did, Sylvie? Yeah, I was there. I saw it. That was crazy. Yeah, my eyes are like getting swollen. Hold on a second. That's weird. My nasal passages. Oh no. Let's see. Hey, King Paco. Tammy B. What was I thinking? Hey, hey. Hey, Sandra. Hold on a second, guys. Yeah, I woke up a little nasally, I guess. So what's been going on? What's been going on? Um, it was crazy. I was crazy today. I was watching Rich's show with Mike Volpe, and it was interesting because you try to educate yourself a little bit. I love when Rich explains a lot of his filings, and they just seem to have a disagreement going on. And yeah, I'm not going to really give my opinion on that. To be a little respectful, because I just a little disrespect was happening there, and that's all I'll say. um, but it kind of sucked that Rich didn't get to explain uh, his filings, and it was kind of being rushed to go through them. That really sucked because a lot of people go there to listen to Richard explain his filings, and so yeah. Uh, Mike hates Palma. Yeah, that may be true, but the reality is when you see unethical behavior, especially by a lawyer, and it needs to be called out. And this guy, Shocket, it constantly does it. I mean, by not by telling the court that he certified you, and he's certifying that he emailed you or the filings. That's bullshit, and he's done it to me 3 times. As a matter of fact, one time we were talking about one of the filings or whatever, and Shocket one night, and it was like almost midnight, and I'm like, yeah, I'm like, what's this bullshit too? I'm like, he sits there and he says he emailed these filings to me and certified and I'm like, I didn't receive shit. Within 5 minutes, I had it in my email, so he's listening. And I was laughing about it. I don't know if any of you remember. It was such like a one-off thing, but it was midnight, and he sends it to me because he realized, oh shit, I didn't send it to her or something. I don't know, but he's done it several times, and he's just sneaky, very very sneaky. And I did file a bar complaint on Shocket, and it's funny because he responded to it. He's like, "This is just harassment," because he's getting a bunch of them in a short period of time. But what he doesn't seem to look at, and or probably knows and just is trying to act like a victim, is simply the fact that when you're in litigation and you send a bar complaint, they won't really open a case about it because the litigation is still open. And I remember that because I believe Bruce sent in a bar complaint about Shocket, and the case was still open, so they didn't do anything. So the case, and he keeps saying the case is still open as far as Fed 2 goes. Yeah, the case is still open with regards to Rich and Michelle, not me. I'm dismissed. The case is dismissed against me and not 8 other people or 7 other people, because I'm one of the 8. So I can file a bar complaint, and they will open a case. And guess what? They did. And in his response, oh my God, the lies, the shady shit. I mean, he even tried to prove something by attaching an appeal, right? And I'm like, what appeal was this? I assumed it was something on the appeal with Daniel Owens. And I'm like, because I'm reading his response, and then obviously I'm going to read the exhibits afterwards. And I'm thinking, so he won the appeal with Dan Owens? No, he did not. We would have heard all about this, right? So I finished reading his response. I'm laughing, and I'm like, oh my God, this guy's an idiot. Poor me. We're all harassing him now. Yeah, bullshit. So I get to the exhibits, and I look, and this appeal is an appeal that has to do with Michelle's case, and it's dated August 7th, 2024. And I'm like, what? What is this even from? And I'm like, hold on a second. And it's about the the Thomases and his recusal, and I'm like, why is this even mentioned in my bar complaint? You know what I mean? I said nothing about this. I didn't even speak about Hells or anything that, his bad behavior or anything until that fight with Guapo, which is August 4th, 2024. And this appeal was 3 days later. I didn't even know who Michelle was, or anything about the case. I was like finding out like right within that next 2 weeks of time. Like I'm like, what? I'm like, this is bullshit. So I actually did a rebuttal to his response. And let me tell you something, guys. It is long. It's like 20 pages. And I went after everything he said. I showed all the proof. Um, you know, when you're a lawyer and you have clients and they're constantly committing bad behavior like harassment and things like that, and you know about it, you're supposed to pretty much walk away when you know that it's criminal behavior. Harassment is criminal behavior, and he's just unethical, and he tried to explain it away. So what I did was I took a whole bunch of videos of his clients, and I wrote up the transcripts for it, and I sent the transcripts in. And I can tell you right now, that's some nasty shit. It's some nasty stuff, and I don't think the bar is going to appreciate that. So there's transcripts of his clients, of him with Larry Foreman, because Larry Foreman was a client of his, and Shocket, his partner, and Mark Feathers were all on a live together, laughing, drinking, doing some more than that. It definitely appears that way anyway. And like totally going off on Judge Thomas's before he was recused. Just like some crazy shit. And this guy is just so unethical. So a whole bunch of stuff went over there. I will read my rebuttal to you, but right now, guys, my eyes are like they're like swollen. I don't know. Maybe I have like a sinus cold or something, or it's coming on. I don't know. I won't be able to read that whole thing yet, and it is 20 pages. So cool. I was just going to ask if you could respond to that. Yeah, I did respond to it. I don't know if he gets to respond again, but I sent it in this morning. But that was really good. I think it was really good. And I don't know. But there is a case open. There's several cases actually open. And usually, from what I understand, the bar doesn't necessarily open cases unless they deem them to be worthy. And there's open cases now. So, yeah. It's quite interesting, guys, and I will read it to you. It's just I really don't think I can. I'm going to try and read this here, see how far I get. But there's a lot of bar complaints going on right now, and especially there's bar complaints against Larry Foreman too. I hope that the Florida bar pulls Shocket's like. Well, it's quite possible because the behavior that he's been pulling for the past 2 years has been pretty bad, and he's got a pattern of behavior like that. He's got a pattern of shady, sneaky shit, and it's been pointed out in a very big way. So who knows? You never know. Whether can he get disbarred? Yes. Will he? I don't know. But he could get suspension. There's lots of things that could happen, but they have to, I'm thinking that they'll bring it to the committee, if anything. Foreman complaints are in Kentucky. Yes, the Foreman complaints are in Kentucky. And apparently he's got himself in a pickle. So anyway, as far as like Foreman goes, his violations are pretty bad. Let's see. Foreman's violations. Let's see. In a guest appearance on YouTube live stream on June 17, 2026, to discuss a famous murder case, Larry Foreman announced the host and her audience of 47,000 viewers of the video so far. God forbid if anywhere in the country they have any type of injury. Yeah, anywhere, all 50 states. We covered the entire. Oh, this is where he was advertising for himself. Rich was talking about this, I believe. We cover the entirety of the United States. I'm licensed in Kentucky, but I can pro hoc vice anywhere. And Rich was saying, like, no, you can't. And they were explaining today how you have to be basically approved, and it's on a per case basis. Can you use a program that Davis uses that reads the motions? Oh, you mean Super Dave? Um, huh. I have a speech thing on here, but I'm not sure how to use it on. Hold on, let's see if I can do that. No, that's not the speech. Yeah, I'd have to set that up and do it. I don't have it set up. So I was gonna say if Leslie was here, that'd be fabulous. She'd go through it. I don't even know where Robbie is. But anyway, so what he was doing was he was advertising nationwide pre-suit representation and personal injury settlement negotiations, stating that it's easy and a lot of cases get resolved without a lawsuit, before announcing his phone number. And the comments appear beginning. Okay, so this. Okay, so here I'm reading off these violations here. But basically, he was advertising himself practicing law without a license in 49 states to pre-suit representation to resolve cases without a lawsuit. And that creates an inherent conflict of interest in violation SCR 3.130, because it creates a significant risk that the representation of one or more clients will be materially limited by a personal interest of the lawyer. For any non-Kentucky client who hires him believing he could and would file a lawsuit in the event settlement negotiations fail, they're being misled. Foreman's personal interest would be in cramming a settlement through to earn a contingency fee without filing a lawsuit, because he knows the client would end up hiring a different in-state lawyer to file a suit if no settlement were reached. Wow. So there's a bunch of stuff here, guys. I can't read it. I really can't. My eyes are like totally swollen. Let me see. Richard can read it. Richard, what are you doing? Well, he says, show your response to Shocket in the marketplace. I was just talking about that, Leslie. I can't read it. My eyes are like totally swollen, and that's 20 pages. I'm having a problem reading this one here. I started it. You want to come on and read it? Be my guest, or Rich. Give me a minute. Maybe I should have waited to talk about that. Maybe my eyes will. Hold on. Let me see. Give me a sec, guys. Sorry about that. I know it's late, but yeah, my eyes are swollen. Hold on. Hold on, guys. What is up with that? Oh, yeah. Okay. Well, that explains it. They were definitely swollen. I shouldn't have done that. I don't know. You think I should put eye drops in my eyes if they're swollen? All right. Let's see what happens. Let's get Robbie. Robbie should be up here soon. Let's see. This was the best response to Shocket that she's at the Florida bar. It was pretty good, man. I got to pat myself on the shoulder. Sounds like an allergy. Yeah, I just because I fell asleep and then I seem to have woken up like this, and my eyes were bothering me, so I actually had those glasses on that takes the blue out of the screen. But now it seems like I'm all nasally. Uh, he said email him a link. See, I didn't even see that. Hold on. Let me get you a link there, Richard. Sorry, guys. Sounds like I'm off to a bad start tonight. All right, here we go. Rich, where are you? Rich, save me! Come save me. I can't read. All right, so Rich should have the link now. Lisa sent me a response to Shocket, and I don't know how he couldn't be disciplined if not disbarred. Stop. Do you want me to read your response? Sure. If you want to come on. I'm sorry. My eyes. I don't know what the hell. It just happened. Like I guess within the past hour. I've learned a lot from you guys. Let's see. Shocky failed as a dentist, failed as a lawyer. What's he gonna do next? Be a dog poop picker upper? You're funny, Harper. All right. Yeah. So we'll get Rich and Leslie if you want to come on and read mine. That's cool. I think I'm turning Japanese. I don't think so. You can put some witch hazel on Cabo. I don't think I have any witch hazel. But if I put eye drops in my eyes are going to get really blurry and I really won't be able to see. Oh my god. Let's see. Well, what I did was I attacked every point that Shocket was trying to, complain. He's a victim. I mean, yeah, is he a victim? I don't take him as a victim. I mean, yeah, in the sparkling light, obviously he's got to answer to it. But I really don't think he's a victim. He said, thanks a lot. Now that's in my head. Sorry, Lord. I didn't know they have allergy eye drops now. I've heard they're so awesome. I just have like dehydrating drops, but I mean they do help. But if I put them in my eyes, I'm not gonna be able to see for a minute, even though I already can't see. Yeah, he's definitely not a victim, but he's acting like it. That's for damn sure. But he's not gonna get away with it because in that, I mean, he lied so bad in his response, and I totally hey Rich, what's going on?
Hello, how are you?
Hi, I can see you. How you doing?
I'm okay. Okay.
I was so glad to see your show today, but then it was like I was trying so hard. I was trying so hard not to say certain things in the chat. I'm like, I was at one point, I was like, I gotta go before I say something bad. But how you doing?
I think it went okay,
Well, it didn't. It's always good to have a debate, but in my opinion, anyway.
Yeah. Well, it is what it is,
Yeah.
Mike is Mike. Mike has stuff he wants to talk about, and it is what it is. He thinks that I should like play the upper, like play the high road,
Right.
with Germ and be like, oh,
Yeah.
well, just you already put stuff into the court and let the court run its course. But I'm like, Mike, you're the one who said like last January and last April that Belitho was sitting on shit, and it took how long to get shit done? Like a year and a half ago, he's saying this shit, and
Right.
like that. Number one, number two, these idiots go on and they're going to talk about shit all day long. They're going to talk about, all the, all the stuff and all the papers and everything else, pile them up. So,
Mhm.
It's like you're going to sit there and, what, you want to just wear a bulletproof vest and let everybody shoot you, or do you want to shoot them back? You know,
Right.
I'd spend my money on fucking guns and bullets as opposed to bulletproof vests. I'd rather shoot them back so they don't fucking shoot me. That's just how Mike is, though. Mike goes, "Oh, should just sit there." No, Mike, that's not. And he's not even been sued yet. That's the thing. He was not sued. He's
Yeah.
not in any of these lawsuits. You
Yeah.
know. So I don't know.
Yeah.
Different story about all that shit.
Well, I know that you guys were going over, you know, the like Foreman too.
There we go.
And I have this up here, and I can't really read it. If you want to read it for me,
Yeah,
I'll
put it up. I'll
this
read it.
Let's see.
Larry Foreman.
Yeah, I kind of went over the beginning of this. I was able. Oh God! All right, I was able to read this. Hold on. Let me zoom in here.
Okay.
You got it?
Yeah. You want to start from the beginning or where?
Yeah, you can start up there. There you go.
Factual basis for Larry Foreman's violations of SCR, that's Supreme Court Rule 3.130, 7.1, SCR 3.130, 5.5, SCR 3.130, 1.7, and SCR 3.130, 8.4. In a guest expert appearance on a YouTube live stream on June 17th, 2026, to discuss a famous murder case, Larry Foreman announced to the host of her audience of 47,000 viewers of the video so far, quote, "God forbid if anywhere in the country they have any type of injury, yeah, anywhere, all 50 states, we cover the entirety of the United States. I'm licensed in Kentucky, but I can pro hoc vice anywhere," close quote. He then advertises nationwide pre-suit representation in personal injury settlement negotiations, stating, quote, "It's easy, and a lot of cases get resolved without a lawsuit," close quote, before announcing his phone number, 1-844-774-HURT. These comments appear beginning at 105.10 timestamp of this link. That's the link. Foreman is advertising himself practicing law without a license in 49 states for pre-suit representation to resolve cases without a lawsuit. This creates an inherent conflict of interest in violation of Supreme Court Rule 3.130, 1.7, because it creates, quote, "a significant risk that the representation of one or more clients will be materially limited by a personal interest of the lawyer. For any non-Kentucky client who hires him believing he could and would file a lawsuit in the event settlement negotiations fail, they are being misled. Foreman's personal interest would be in cramming a settlement through to earn a contingency fee without filing a lawsuit, because he knows the client would end up hiring a different in-state lawyer to file a lawsuit if no settlement were reached. For example, if Foreman represents an Idaho client and there was $100,000 offered to settle an injury case, but the client's claim may be worth a lot more if litigated, Foreman's financial interest is served by advising the Idaho client to settle, so in which case Foreman earns a contingency fee. If he advised the client to sue because the final settlement offer is insufficient, he'd end up cut out of any recovery when the client realized they need to hire a different lawyer in their own state. This is exactly the type of personal interest in the lawyer that creates a conflict that Rule 7.1 prohibits. Foreman's claim that he can negotiate pre-suit settlements in all 50 states constitutes multi-jurisdictional practice under Kentucky Supreme Court Rule 3.130, 5.5, which prohibits a lawyer from establishing a systematic and continuous presence in another jurisdiction or holding out to the public that the lawyer is admitted to practice there. Pre-suit negotiation in another state where you are not licensed is the unlicensed practice of law. Advertising that you do it everywhere means you are misrepresenting that you can practice law everywhere. Foreman's statements violate Rule 7.10 for false advertising, Rule 5.5 for holding himself out as having multi-jurisdictional practice, and Rule 8.4 for misrepresentation. Additionally, Foreman's website appears to contain false claims of large personal injury settlements. The website's front page has 8 boxes with the phrase personal injury settlement. And in each box is an amount: $150K in 4 boxes, $250K in 1 box, $350K in 2 boxes, and $750K in 1 box. This is a representation that his firm achieved case settlements matching each of these 8 amounts in boxes. Considering Foreman's statements falsely advertising themselves as available in practice in all 50 states, the bar should also investigate whether Foreman can support the 8 boxes advertisement by identifying the 8 personal injury cases settled for the claimed amounts. This advertisement appears to be made up for visual impact, but are likely not based on actual case settlements. This would constitute violations of Rule 7.10 and 8.4. Do you have that graphic, Lisa? I have that graphic if you want it.
No, I don't. I just have this one.
I'll share it. Hold on, let me share it with you.
Okay.
I'll share it on the screen. All right, Larry Foreman. Here it is. Let that go. Put that up.
Hold on. It won't remove. Yeah, let me close this. If I close it, it'll just disappear. Poof. All right.
Now that is what his website looks like. And that's what we call, if he doesn't have settlements or in those amounts, that's what's called false advertising. And when you're a lawyer, you have to tell the truth.
Right.
That's false advertising. So look at that.
Wow.
Look at all that money. That's what? 150, that's 3, 450, 600, right? 600 plus 750, 1.3, 1.3, right? 1.350. 1.350, 1.4, 1.7, right? 1.7, 1.95. So what's that, like 2.3 million we're talking about, right?
Yeah. That's crazy.
So he has 2.3 million in personal injury settlements, and he's the DUI lawyer. He's not the personal injury lawyer. So he's got 2.3 in personal injury settlements. All right. Show us that.
Wow.
I think
That's
you should deep cocky poo poo.
All right, here we go. What I'm going to do, Rich, is I'm going to actually send you a copy of my rebuttal so you can scroll through it as you read, because my eyes are so messed up. And like reading along is messing them up even more. I'm so sorry. But everybody wants to hear. Do you mind?
I don't care.
Okay. Hold on. A lot of people were wanting to hear my rebuttal. Now, do you want to see his response? I mean, it's long.
Yeah, show what the hell. Let's start with his.
All right, hold on.
You read yours, right?
No, I didn't. Oh, my original?
Yeah.
A bar complaint? Yeah, I've already done that.
Yeah, you did that the other day.
Yeah. Let me get his. Where the hell is it? All right, here, I'll send you this one. This is mine. Let me get his. Hold on.
I got one we can set the scene with. We can set the scene with that picture.
Guys, just letting you know it's going to be long because his is long and then mine is 20 pages. You don't have to read the like you can skip through certain rules and stuff.
Well, but it's bullshitty. Yeah, I'll just bullshit.
Yeah. Okay, it's coming. It's coming.
Okay.
Got that song in my head now. All right. Cool. All right, so you should have that coming too.
I got your rebuttal, and I got the. I'll do the other one. I'll do the other one first.
All right. So let's remove that, and then it won't. Now, if you got to take that down, I think, in order for me to add that. No, maybe not. It's not. All right, you actually got it from here. So I just have to. Oh, do I have to put that up?
Put it up. Put it up. Put it up.
All right, hold on a second. All right, so in case you don't see, I got my fair use up there. Let me just remove my banner for a minute. Okay. But this is a public picture, so here we go. This is Randall Shocket.
Randy, the pocket rocket Shocket, looking
Okay,
as charming as the serial killer.
yeah.
I love it.
And this is I did send Leslie the link, but she's gonna Rich is gonna read it.
I'm going to
Um,
read it. Okay, let me pull both.
so if she wants to come on, I sent her the link anyway. Um, all right, so you should have both now, Rich.
Yeah, I'm just grabbing them, getting them good to go. Let's see.
Yes, there is complaint. There's a couple of complaints in Kentucky.
Okay, you want Shocket. Shocket's response is right here.
Yeah.
Perfect. Okay, save that. All right, now what I can do is just knock all this out.
And Rich, just when you start reading that, I'm just gonna try. I'm gonna go get an ice pack too. So
Okay.
I'll wait till you start reading that though.
Yeah, let me wait till I put it up, and then you can do
Yeah.
those. All right, let me do this. I'm going to open up all of this. Let's see, Hales, Shocket. Okay, just save those two. Perfecto. And now, let's see. Is it open? Yes. Okay, perfect. Okay, I'm going to hit the button to make you put it up. Now, let's see, where are we? Okay.
My eyes are just swollen. I can feel like a little nasally thing, and my eyes are a little swollen. So it's making it hard for me to read. I mean, I could read, but not in that length. It's just
All right,
making
we
it.
good?
There you go.
Shocket Law Group. You like that, right?
Yep.
All right.
A little public information.
Okay, but hold on. Let me see. I'm at, see if I get a little bigger. Want to go bigger? There we go. Okay, good. Shocket Law Group. All right. June 23rd, 2026. Personal and confidential to Allie F. Houston, Esquire, the bar counsel for the Florida Bar in Tallahassee. Inquiry and complaint of Miss Lisa Lee against Randall Mark Shocket, Esquire. Mrs. Houston. This letter serves as my response to the complaint filed by Miss Lisa Lee in the above referenced matter. I respectfully submit this complaint is entirely without merit and represents yet another transparent attempt by an adverse party to misuse the bar's disciplinary process as a weapon in ongoing civil litigation. Ms. Lee's complaint must be understood in its proper context. Ms. Lee was a defendant in federal litigation where I represented the plaintiffs, Jeremy Bryan Hales of Elephant Shoe LLC. Ms. Lee's complaint involves disputes about litigation strategy, discovery, conduct by clients, speech activities, and the outcome of judicial proceedings, all matters that are properly resolved in civil court through motion practice and appeals, not through bar discipline. The Supreme Court of Florida has ruled the disciplinary process and proceedings are not to be used as substitute for civil proceedings and remedies. Ms. Lee's allegations are a transparent attempt to weaponize the bar's disciplinary process against counsel representing clients in legitimate civil litigation.
By the way, nobody else has this, so if it appears on tomorrow's channels, the Minions channels, they got it off of here. Sorry, go ahead.
Response to Ms. Lee's specific factual allegations, the deposition issue, case status of Ms. Lee's failure to appear. Ms. Lee makes several material misrepresentations regarding the deposition scheduled for January 24th, 2025, in case number 1:24CV45RH-ZCB. That's Fed 1, right?
Yeah.
I address each misrepresentation below. First, Ms. Lee incorrectly states or implies that the case has been dismissed. This is false. The case remains active, has not been dismissed. The case has been stayed twice. Once for when Ms. Preston's attorney, Bruce Matskins, withdrew from representation and the court allowed her time to obtain new counsel, which she never did. And two, again, due to Ms. Preston's bankruptcy filing in July 25, with the stay remaining in effect to date due to the pending bankruptcy proceeding. Second, regarding the January 24th, 2025 deposition, I appeared in person at this deposition with a court reporter. Ms. Lee failed to appear. Third,
He
Ms.
did
Lee
not.
admits
Bruce was there. But go ahead.
Ms. Lee admits to receiving the subpoena. Her email objection sent at 9 p.m. the evening before the 10 a.m. deposition was not a timely objection. The Rules of Civil Procedure 45D2B, while a written objection may be served before the time specified for compliance, an objection served at 9 p.m. the night before deposition does not provide reasonable notice or constitute adequate grounds for non-appearance. Or Ms. Lee's email object only the timing for producing documents. She did not object to her requirement to appear for testimony, nor did she file a motion to quash Rule 45D3 or seek a protective order, Rule 26. The
No
email
one did.
exchange, opposing counsel Bruce Matzkin and myself on January 24th confirms that I appeared with a court reporter, that Ms. Lee failed to appear, and that her last-minute email objection was insufficient to excuse her non-appearance. Fourth, no attempt is made at this point to collect fees or file a motion for contempt regarding Ms. Lee's failure to appear. The discovery dispute remains unresolved due to the case stays described above. Ms. Lee's false statements regarding service of the amended complaint. June 27, 2025, Ms. Lee filed a motion for leave to file an amended motion to dismiss, where she represented the court on 5/10/25. Lee was served with the original complaint that was filed on 2/23/25, citing defamation claims, and the plaintiff was never served defendant Lee with the amended complaint. These representations are material false, and I can prove it. On May 6th, I sent the amended complaint and its attachments to the process server for process on Ms. Lee. On May 8th, Ms. Lee was served with the amended complaint and its attachments along with a summons, as confirmed by the return service affidavit. Prior to Ms. Lee filing a motion for leave, I advised her during meet and confer communication we do not agree, especially claim that you were not served with the amended complaint. We have documentation that the process server has never received anything but the amended complaint for you to be served. Despite this clear notice, the proof existed contradicting her claim. Ms. Lee persisted in filing the motion containing false representations to the court. Moreover, Ms. Lee's own motion to dismiss proves she relied on the amended complaint, not the original complaint. In her motion, Ms. Lee references the specific numbered paragraphs and makes arguments based on those paragraphs. These paragraph numbers on the substance of Ms. Lee's arguments match completely with the amended complaint, not the original complaint. Paragraphs she cited from the original complaint refer only to other defendants and do not mention Ms. Lee at all. Additionally, Ms. Lee was aware of the amended complaint because she filed opposition to plaintiff's motion for leave to amend the second amended complaint, demonstrating knowledge of both the amended complaint and the proposed second amended complaint. On April 28th, Ms. Lee broadcast a live stream video on our YouTube channel title, Amended Complaint is in, new defendant added.
Yeah.
During which she stated, so anyhow, the amended complaint containing there's still 10. There's still 10. They removed Patty Plummer and they added Richard Luthman.
Yeah. Let me explain something real quick. What he served me with is what I was ready to respond to, right? So I had it set aside, right? So when the time came for me to do my motion to dismiss, I grabbed what he served me with. However, we had talked about the amended complaint online, but I went by what he served me with, right? And that's just how it was. And then I realized, oh, hold on a second, this was never the second complaint, amended complaint, and that's what basically happened. It was my screw up, and I admitted it. Okay. But because I obviously knew there was an amended complaint. I just thought that was what was in my hand when I went back to the papers he gave me.
Okay. Keep going?
Yeah. Oh, yeah.
Allegations regarding cyberbullying and harassment. Miss Lee alleges that I failed to control my client's social media activities and public statements. This allegation reflects a fundamental misunderstanding of the attorney-client relationship and the First Amendment rights of clients. Attorneys cannot and do not control every aspect of their clients' lives or speech. While attorneys have ethical obligations regarding trial publicity, clients retain their own First Amendment rights to speak about matters of public concern. My clients operate YouTube channels where they discuss various topics, including their own experiences with litigation. Their speech involves matters of public concern, including the operation of the legal system and issues related to online disputes and judicial process. I have advised my clients about their obligations and responsibilities regarding public statements about pending litigation. However, I cannot and do not control every statement they make on their social media platforms. Ms. Lee's demand that I control all aspects of my client's public discussion of litigation is unreasonable and unsupported by any ethical rule. Clients retain their constitutional right to speak about their own experiences and matters of public concern, even while litigation is pending. The rules of professional conduct govern attorney conduct, not client speech. An attorney's ethical duty under Rule 4-3.6 relates to the attorney's own extrajudicial statements, not to policing every word a client says on their own platform. I have fulfilled my ethical obligations by advising my clients regarding their responsibilities. Beyond that, I cannot and should not attempt to silence my client's constitutionally protected speech. Allegation regarding meritless litigation. Ms. Lee alleges that I filed voluminous meritless litigation against various defendants. The fact that some claims were dismissed does not render the lawsuits frivolous or unethical. The federal case, that's Fed 2, the Northern District of Florida, the court granted leave to amend further its March 11, 2026 order stating order dismissing Second Amendment claim and granting leave to amend further. This demonstrates the court did not find my claims to be inherently without merit, but rather found the pleading deficient in form. My clients made a strategic decision not to file a third amended complaint. That decision does not render the original filing frivolous or unethical. The cases I filed on behalf of my clients were based on good faith legal theories, bullshit, and were supported by factual allegations that, if proven, would have entitled my clients to relief. Federal courts routinely dismiss complaints with leave to amend where the legal theory is potentially viable, but the pleading is technically deficient. The fact that the court provided leave to amend further demonstrates my client that the claims were not frivolous. My client's decision not to pursue further amendment was a strategic litigation choice, not evidence of a bad filing. Oh, that's good, actually, because he's admitting that they strategically decided to go ahead with the claims against me in their amendments. So now I can smack them around with that. This is beautiful. Moreover, the filing of civil litigation is a fundamental right. Yeah, okay. Parties have the right to seek redress in court for perceived wrongs, and their attorneys have the right to advocate zealously within the bounds of the law. Ms. Lee's disagreement with
wrongs.
fucking idiots. Ms. Lee's disagreement with the outcome of litigation does not transform legitimate adequacy into an ethical violation. Allegations regarding YouTube channel and public commentary. Ms. Lee complains extensively about my client's YouTube activities and alleges that I participated in or facilitated improper conduct by appearing on videos and allowing my clients to discuss litigation matters publicly. As stated above, clients retain their First Amendment rights to speak about matters of public concern, including their own litigation. The fact that I appeared on a platform to discuss legal matters does not constitute an ethical violation. Attorneys are permitted to explain legal processes, discuss their work, and communicate with the public about legal matters, provided they do not violate specific ethical rules regarding trial publicity, confidentiality, or candor, or any other one.
Right, wait till you see
Ms. Lee references videos in which my clients discuss judicial rulings, litigation strategy, and related matters. She characterizes this as making fun of judges, creating content prejudicial to the administration of justice. This characterization misrepresents both the content and the context. Several months after certain videos aired discussing judicial bias concerns, the First District Court of Appeals granted an extraordinary writ of prohibition, finding that the trial judge should have been disqualified due to demonstrated bias against my clients. A copy is attached. The appellate court's decision confirmed the trial judge had exceeded the proper scope of inquiry by attempting to refute charges of partiality rather than simply evaluating the legal sufficiency of the disqualification motion. The video in question did not reveal confidential information. It was made during the pendency of our appellate petition seeking relief from judicial bias. The subsequent vindication of our position by the appellate court demonstrates that our concerns about judicial bias were well-founded and legally justified, not frivolous or harassing. Attorneys are free to publicly criticize a judge's legal reasoning or the merits of a specific decision, provided it is done in a dignified manner that does not undermine public trust in the legal system. I did not knowingly make a false accusations, allege corruption without evidence, or make personal attacks on any judge's integrity. No, that's what Larry Foreman and Jerry Hales. Yeah. Allegations regarding crowdfunding and false legal fees. Ms. Lee alleges that I participated in fraudulent crowdfunding by allowing my clients to elicit donations for legal fees and permitting my firm's address to be listed in their GoFundMe campaign. This allegation fundamentally misunderstands the nature of legal representation and client autonomy. My clients have been involved in extensive federal and state litigation over the past 2 years involving numerous defendants, extensive discovery, depositions, motion practice, hearings. My clients, like any litigants, have the right to seek financial assistance and pay their legal fees. The GoFundMe campaign was created and managed by my clients, not me. While the campaign description included my firm's address as a location where checks could be sent, this was my client's request and was simply a convenience for donors who preferred to send checks rather than donate online. There's no fraud involved in clients seeking donations to pay legitimate legal fees. Ms. Lee points to alleged inconsistencies in the amount my clients stated they had paid in legal fees at various times. My clients are responsible for their own public statements, and I have no reason to doubt them. Cannot control every word they say on their platform, nor am I responsible for verifying the accuracy of every statement they make about their finances. Furthermore, There is no ethical rule that prohibits a client from seeking financial assistance to pay legal fees. Nor is there any rule that prohibits...
Wow, did you hear him say that? I mean, weren't they saying that it was wrong for John and Michelle to have pooled money to pay for attorneys and things like that? But now all of a sudden, Shocket says there's nothing wrong with it?
Yeah. Nor is there any rule that prohibits clients to list their attorney's address as a place where donations can be sent. Ms. Lee has provided no evidence of any false statements by me or any intent on my part to deceive anyone. The crowdfunding activities were my client's initiative. They created the campaign, wrote the descriptions, made statements about their expenses, managed the funds. The fact that donors were given the option to send checks to my office and I transformed my client's fundraising efforts into attorney misconduct. Allegations regarding attorney-client commingling of funds. Ms. Lee alleges attorney-client commingling of funds based on the fact that the GoFundMe campaign gave donors the option to send checks to my law office. This allegation was without merit. There have been no commingling of funds. The GoFundMe campaign provided donors with two options: donate electronically through the GoFundMe platform, which goes directly to my clients, or mail a check to my law office made payable to my law firm with the notation for Jeremy Hales. Any check sent to my law office in this matter will be applied to my client's outstanding legal fees, the exact purpose for which the donations were solicited. This is a standard and proper method of payment where there's no commingling when funds sent specifically to pay legal fees are applied to the client's outstanding balance. There's no ethical violation allowing client direct their supporters to send payments for legal fees owed by the client directly to an attorney. This is, in fact, the normal way legal fees are paid.
Normal.
Wow.
It's normal.
That's normal.
Mm-hmm.
Dishonesty to the tribunal. Ms. Lee alleges that I engaged in dishonesty to the court by responding to original motion to dismiss after she informed me she intended to file an amended motion. Facts do not support this allegation. On June 27, 2025, Ms. Lee sent me an email stating she would be filing a motion for leave to file an amended motion to dismiss and asked me whether I consented. I agreed what her grounds were. She responded with an attachment. I replied, "We do not agree, especially on the claim that you were not served with the amended complaint. We have documentation of this process. Server never received anything with the amended complaint for you to be served." At that point, Ms. Lee had filed her own motion to dismiss, and I was entitled to respond to it. In fact, she informed me she intended to seek leave to amend her motion, did not deprive me of a right to respond on the motion actually on file. Moreover, as my response in opposition demonstrated, Ms. Lee's stated grounds for seeking amendment were factually false. She had been served with the amended complaint and had, in fact, relied on it in drafting her original motion. There's no ethical rule that requires an attorney to withhold a response to a filed motion simply because opposing counsel announces intention to seek leave to amend. Federal Rules of Civil Procedure do not even authorize a motion for leave to amend the motion, as motions are not pleadings subject to amendment. Ms. Lee's characterization of my conduct as dishonest is itself without foundation. The magistrate judge's order requiring an expedited response was directed at the unusual procedural posture created by Ms. Lee's motion for leave to amend, not at any improper conduct on my part. Ms. Lee's complaint is part of a pattern of harassment. Ms. Lee's complaint to the Florida bar represents an abuse of the bar's disciplinary process. It was filed in retaliation for legitimate civil litigation. Mr. Lee was a named defendant in an adverse party. Ms. Lee's complaint is part of a broader pattern of using regulatory and legal process to harass my clients and me as their counsel. This complaint focuses their disagreements with litigation outcomes, discovery disputes, and my clients' exercise of their First Amendment rights, none of which are proper subjects or bar discipline. It's evident that the matters upon which Ms. Lee's allegations are premised involve a civil dispute, present questions of fact and law. However, the Florida bar is not the correct forum in which to have such factual and legal issues adjudicated, and the resolution of those issues must be left to the courts. Ms. Lee's complaint involves disputes about litigation strategy, the decision to file certain cases, my conduct during depositions, my client's public statements, and the outcomes of judicial proceedings. All matters that are properly resolved in civil court through motion practice and appeals, not through bar discipline. Ms. Lee has civil remedies available if she believes she has been wronged. She cannot, however, use the bar's disciplinary process as a substitute for civil litigation. Conclusion. Ms. Lee's complaint involves civil disputes and presents questions of fact and law that are properly adjudicated at the appropriate tribunal, not through the bar's disciplinary process. Florida bar is not the correct forum to have such factual and legal issues adjudicated, and a resolution of those issues should be left to the courts. For the reasons stated above, I respectfully request the complaint be dismissed. I have complied with Rule 3.71F of finding disclosure to Doreen Inglis as required. Thank you for your consideration of this matter. That's Shocket Law Group.
Oh my God, read mine. You need a break.
Right, here comes Lisa Louise.
Guys, get ready. Oh man.
It's lengthy.
A lot went into this, guys. A lot went into this.
Lisa Lee's rebuttal to Randall Shocket Esquire. I request the Florida bar slowly read all words stated in this rebuttal, as this is lengthy, but crucially important, as Mr. Shocket continues to harm multiple members of the public, warrants possible emergency suspension, if not disbarment. Overview and financial motivations of Mr. Shocket's unethical conduct. Lisa Lee, complainant, respectfully submits that this introduction to highlight a pattern of conduct by attorney Randall Shocket and his client, YouTuber Jeremy Hales, which raises serious concerns regarding the abuse of legal process for personal gain. Under the totality of the circumstances, it appears the lawsuits initiated by Shocket and Hales are not merely standard legal disputes, but rather part of a coordinated scheme designed to generate profit at the expense of vulnerable individuals. This is evident with the voluminous lawsuits filed over the last 9 months, the majority dismissed with prejudice against pro se litigants, and the mechanism in place to fund those legal fees. Lawsuits filed over the last year. Jeremy Hales and Randy Shocket versus Michelle Preston and Bruce Matskin. Jeremy Hales versus Leslie Federicos and Michael Federicos.
Now, by the way, just in the first one there, Shocket is also suing as a co-plaintiff with Hales.
Yeah. Jeremy Hales versus Michelle Preston and John Cook. That's Fed 1. Jeremy Hales versus John Cook, Bruce Matskin, Lisa Lee, Marla Hughes, Patty D'Agostino Plummer, David Helm, Robbie Kesey, David Michael Teschendorf, Raymond G. Brombeck, Michelle Preston, Richard Luthman, and it was dismissed with prejudice except for everybody but Michelle and me. And then Jeremy Hales versus Daniel Rex Owen. That one went swimmingly for Jeremy. Jeremy Hales had branded the following pro se defendants with disparaging nicknames for his YouTube live stream content. What the hells? Lisa Lee is Walrus, Fleece, Fat Lisa, Fatty. Her husband is Sugar Booger and Poppy Seed. Michelle Preston is Lynette. John Cook is John Crook. Bruce Matskin is Deuce. Richard Lewis is Paint Chips. David Michael Teschendorf is Whopper or Stupid Lane. Leslie Federicos is Lips. Michael Federicos is Chips or Doritos. Marley is Marley Huge. The modus operandi is as follows. Defendants, often individuals of limited means, unable to secure legal representation, are sued by Shocket and Hales. These defendants appear pro se against Hales under the representation of Mr. Shocket. Concurrently, these lawsuits are transformed into online spectacles, with the entire legal process broadcast on YouTube in a mocking and entertaining manner. Throughout these broadcasts, defendants are repeatedly portrayed in a negative light and branded into characters, further compounding their vulnerability. During this time, Mr. Shocket's client, particularly Mr. Hales, seeks out crowdfunding donations premised on falsehoods about the status of the cases and branded character of those they are suing. This arrangement creates a self-sustaining cycle of revenue generation. Online audiences led to believe they are supporting legitimate pursuit of justice are solicited for donations, purportedly to cover legal expenses. In reality, these costs are offset by funds raised through the streaming, crowdfunding, and plaintiff monetization, with the surplus potentially shared between attorney and client. As the number of lawsuits increases, so too does the volume of online content, by extension, the financial gain. This is easily proven by watching the content of Mr. Shocket's clients' YouTube channels. And look at this. We have thumbnails. Example. And the practical effect is a business model that exploits the legal system and the public's goodwill while disproportionately harming defendants lacking resources to adequately defend themselves. The only parties incurring real harm are the indigent pro se parties, subjected to public disparagement and legal jeopardy without a fair opportunity to respond, and the well-intentioned donors misled to the true purpose of their contributions. Complainant submits that this practice constitutes an abusive process and warrants the court's careful scrutiny and immediate attention. Mr. Shocket attempts to play as if he doesn't know what's going on and his client's actions are separate from him. However, substantial evidence in this rebuttal will prove otherwise. Lisa Lee prevailed as a pro se litigant against Mr. Shocket. Why my bar complaint against Mr. Shocket is justified. Mr. Shocket attempts to claim my bar complaint as a pattern of harassment. However, it is important to point out that I prevailed against Mr. Shocket as a pro se litigant when the court dismissed Mr. Shocket's claims against me with prejudice in the only case I was involved with Mr. Shocket. That's Fed 2. It's absolutely appropriate for me to inform the Florida bar of Mr. Shocket's unethical conduct during litigation against him. The fact I prevailed against Mr. Shocket in a pro litigation speaks volumes and further strengthens my credibility to the allegations against him in this bar complaint that I filed after all claims were dismissed with prejudice against me. Mr. Shocket once again misrepresents The uncontested fact that federal lawsuit Fed 2 has been dismissed against 9 pro se defendants with prejudice. The only reason that anything remains open on this case is because the court cannot dismiss claims against defendant due to a stay in bankruptcy, and the other defendant had an issue with service and jurisdiction. Mr. Shocket attempts to claim that claims dismissed with prejudice against 9 defendants not valid because his opportunity to amend his own complaint. However, it is vitally important the Florida Bar reads the report from magistrate, an order from judge confirming this dismissal against the 9 pro se defendants. Mr. Shocket claims strategically he and his client chose not to amend, however, he fails to explain the court's words in the order report warning him against it. Mr. Shocket's claim was dismissed with prejudice, and the court allowed him to amend based on adding unrelated claims, but they did so while advising Mr. Shocket with caution. Thus, Mr. Shocket once again misleads the Florida Bar, manipulating solid, uncontested facts, evidencing his issues with candor. Randall Shocket, Esquire, misrepresents that he appeared at the deposition. At the time Shocket saw my deposition, I was not a part of the case. My depositions were not relevant to the case. I later learned that Shocket was attempting to depose me and other non-parties in connection with a separate lawsuit he intended to file. He used an unrelated case as the pretext to pursue depositions for this other matter. Most recently, he attempted to partake in the same conduct, claiming he needed my deposition in a bankruptcy case that has no relationship to me. Mr. Shocket attempted to serve me by leaving a subpoena on my outside patio table, which is discovered later. I was not properly served. I was not given a proper time to respond, and no check for my appearance was included as required. I informed Mr. Shocket by email that due to improper service and lack of notice, I will not attend the deposition. He was fully aware of this, and I provided this email to the bar in my initial complaint. As a result, I did not appear. Mr. Shocket later told the Florida Bar that he appeared for the deposition, which is untrue. Attorney Bruce Matzkin appeared instead, and I provided an email from Mr. Matzkin confirming Mr. Shocket did not show up. This evidence is included in my initial complaint to the Florida Bar. Mr. Shocket has never pursued an order of contempt against me, and as he knew I was not properly served, and he was not attending the deposition himself. It's extremely concerning that Mr. Shocket, a licensed attorney, provides false information to the Florida Bar. How Mr. Shocket's deliberate litigation tactics undermine good faith efforts and obscure the real issues before the court. Randall Shocket, Esquire, admits in his response that Lisa Lee informed him in good faith pursuant to the federal rules for meet and confer, and she had filed a motion for leave to amend. He further acknowledges that despite knowing Ms. Lee's motion for leave had been mailed to the court for docketing, he still chose to respond to the original motion the following day. This conduct demonstrates the type of attorney Mr. Shocket is. His own admissions reflect what's considered bad faith litigation practice. Mr. Shocket argues that no rule expressly prohibits him from responding to the original motion to dismiss once it is filed, and he fails to justify why he would do so after a pro se litigant made a good faith effort to inform him that a motion for leave to amend, along with an amended motion to dismiss, had already been mailed to the court. There's no reasonable explanation for why an attorney, once informed of amended filing, would choose to waste the court's time and his client's money by responding to a superseded motion. This behavior bears to be for Mr. Shocket's own benefit and is indicative of his intentional tactics to confuse and mislead the court and further cause unnecessary stress for pro se litigants. Mr. Shocket consistently makes misstatements of fact and muddies the issues, both litigation and his dealings with the Florida Bar. The record in the case, Fed 2, directly contradicts the position Mr. Shocket's presented to the Florida Bar. The central issue is his bad faith response, made with knowledge that an amended response had been mailed, not the elaborate explanation he offers regarding service of the initial or amended complaint. His attempt to deviate from my allegation only highlights his tendency to avoid directly addressing the actual claims in my bar complaint against. Rather than addressing the substance of the allegations, Mr. Shocket introduces irrelevant matters, attacks the character of those who oppose him, and takes actions meant to confuse the key issues. This pattern is consistent with the concerns raised by the Arkansas Bar, which cited his lack of remorse and accountability as a reason for denying him a license to practice law. The situation itself is straightforward. After I mistakenly filed a motion to dismiss the initial complaint, I realized the error and sought leave to amend my motion to dismiss in accordance to respond to the correct operative amended complaint. Acting in good faith in accordance with the federal rules for meet and confer, I notified Mr. Shocket that I had filed a motion for leave to amend, which included my amended motion to dismiss. Though the amended motion had not yet been docketed, it had been mailed and it was soon to be received by the court. Despite this, the day after receiving my notice, Mr. Shocket intentionally responded to the original motion to dismiss, fully aware that it had been amended and that a motion for leave to amend with the attached amended motion had already been mailed. The court ultimately granted my motion for leave, to not making a ruling against me, as reflected in the court's order. It is troubling that Shocket would make false statements to the Florida bar, who are themselves attorneys and can easily verify the facts on paper for the case. Mr. Shocket is directly involved with his client's cyberbullying and harassment. He uses this as a way to intimidate parties to whom he's litigating against, not protected under the First Amendment. Contrary to Mr. Shocket's claim, he cannot control what his clients say or do. Mr. Shocket is fully aware of his client's out-of-court cyberbullying and harassment campaigns. His client, Jeremy Hales, has publicly discussed Mr. Shocket's involvement, so much as to state that Mr. Shocket is in control of what he does and that Jeremy Hales defers to Mr. Shocket as to what he can publish. See the following timestamps, transcript excerpts, where Randall Shocket's client, Jeremy Hales, directly points out Randall Shocket's involvement with his content published in his YouTube channel as follows. There's a link there. And what's this part? Randy's watching right now, and he's telling me not telling me to shut up. He's actually saying what we can do. This and we can do, and now he's giving us more. He's giving us more what we can do because they've done this to us. So we're not going to get into. Employed by me or controlling me, anything. He controls me, telling me what I can say and what I can do, what I can't say and what I can't do. Let's say George, for instance, if anyone in there, right. So, all the parties who have been harassed and served notices directly to Mr. Shocket with URLs, screenshots, proof of harassment, requesting Mr. Shocket advise his clients to cease and desist this type of conduct during litigation. However, Mr. Shocket does nothing, including withdraw from representing his clients after being provided proof of the harassment. Florida Bar Rule, except the state in subdivision C, and this is Rule 4.4-1.16. A lawyer shall not represent a client where representation has commenced, shall withdraw from the representation if the representation will result in a violation of professional conduct or law, the client persists in a course of conduct involving the lawyer's services the lawyer believes is criminal or fraudulent, unless the client agrees to disclose and rectify the crime or fraud. The client has used the lawyer's services to perpetrate a crime or fraud, unless the client agrees to disclose and rectify the crime or fraud. I have an open criminal investigation of the conduct of Mr. Shocket's clients, which raises it to the level of criminal, cyber harassment, cyberbullying, fraud, among other possible criminal violations. Mr. Shocket takes no action on any level to do anything while having direct knowledge of what his clients are doing. Why? Because he's benefiting from this harassment financially and in his litigation. As long as clients can make entertaining content from the voluminous, frivolous lawsuits they have filed with Mr. Shocket's representation, they cannot be determined a vexatious litigant because Mr. Shocket represents them regardless of the frivolous nature of the lawsuits. While these clients are pro se, not knowing how to get Mr. Shocket sanctioned for his frivolous conduct. Furthermore, Mr. Shocket's clients get more view counts on their live streams, therefore getting more money for monetization. While this is done, his clients falsely depict the status of the lawsuit and character assassinate the defendants on their YouTube channels, all while crowdfunding their legal fees, which Mr. Shocket benefits from. It is a perpetual vehicle that allows both his clients and him to financially benefit from mocking and exploiting the legal system at the expense of the public. Additionally, 90% of the defendants he chooses to sue are at poverty level without the financial ability to retain counsel. This allows him to have a very little backlash legally or go under the radar during his scheme. But it doesn't end here. Mr. Shocket claims his clients are producing content that is protected under the First Amendment. However, doxing defendants' information, making fun of their physical appearance, gender, disabilities, publishing full statements about them during litigation to audiences of over 100,000 is not protected under the First Amendment. Quick review of the nature of the content. His clients publish their YouTube channels about defense of the lawsuit they are suing during active litigation. This demonstrates beyond speaking of public concern, reporting on their cases. They're just the thumbnails and don't even depict the egregious nature of what these live streams discuss, making fun of defendants' appearance, weight, disabilities, placing them in jumpsuits like criminals. It is clear just upon viewing the thumbnails is not the nature of how Mr. Shocket has informed the Florida bar that his clients are publishing during litigation against defendants they sue.
And there's plenty more where that came from.
And these are the thumbnails.
You need a break, Richard?
How long is this? Pretty long, huh?
Yeah.
Excerpt from published videos, and that's the videos. Contrary to Mr. Shocket's depiction of his client's content, here are just a few statements from Jeremy Hales against me as a pro se defendant from Jeremy Hales live streams. These statement attacks my weight. I am threatened, among other things, other disturbing things stated during these live streams. This does not include the voluminous attacks Mr. Hales made against other pro se defendants and their families that Mr. Shocket is fully aware of. Transcript.
You don't have to read all that, but there's a
I'll
bunch
do
of them.
I'll do these. If I put a P on a PPI and anything like it's 100% legal. So stop your baby and crying, you're whining. Lisa wanted this. Lynette wanted this. Phonehead wanted this. Stupid Lame wanted this. You got it. About 200 pounds of polyflop right in here. Refuse to show their face. We don't know whether it's female or male. We're not playing nice today. Ugly on the inside, outside, looking old and fat. You joke, not a threat. Pretty bad when she's hated. Probably one of the most hated individuals on YouTube. Fleeces chicken wings or the chicken skin or the 50-pound chicken under the arms, or do you think that hair right there, what's bigger? Her arms is wider than my torso. It's frightening. Bigger than my thigh. Her arm is thicker than my thigh. I am 6'2", 230 pounds, built like a brick shithouse, and her arm is bigger than my thigh. Now I'm part of their life, the rest of their life, and I will be creditors in Lips and Chips bankruptcy court. We'll have firsthand knowledge of everything going on, and we will provide federal court with everything they've done, as if they know anything about praying, as they know anything about spiritual life, the garbage lives that their lives are. If we hit the goal again, we're going to laugh at Lisa. She continues to choke on chicken skins. It's going to be hilarious, I promise you that. Even if Fed 2 gets dismissed, you're still going to court, fatty. You're going to court. You're being sued for everything you've done, everything you continue to do. Even if Fed 2 gets dismissed, you're still going to court, fatty. She's immoral. You're going to have FOIAs on every location you've ever been. You're going to have Bonehead. You're going to have Stupid Lame. You're going to have Making Libel Simple. You're going to have Marla Hughes. And here we go. And this is Larry Foreman. And look at this. This is a judge dressed up as a clown. There's a judge dressed up with a beanie on. Right? Which can does the judge violate? Pretty bad. Here's more. Judge Thomas is depicted as a clown, dunce, worst judge in Florida, Peeping Tom. Adversarial attorneys defamed for claiming Florida attorney faces debarment for shocking action, say lawyer exposed, scam attorney exposed. What is concerning is this was during active litigation where Mr. Shocket was representing his clients, and they were publishing this type of content against a sitting judge in their case as an opposing counsel, who they also sued as a defendant. Real photographs are used of judges, attorneys, and defendants they're suing during active litigation. Mr. Shocket admits that in his response, he can only do so much or advise his client so much. However, it's apparent that he should have withdrawn from representing his clients, that they're engaged in this type of cyberbullying attack against judges, attorneys, defendants during active litigation. Today, his clients continue to publish this type of content against other litigants. In cases still active, Mr. Shocket has a duty to withdraw from representing a client when they fail to correct conduct that could rise to this level of harassment against the judiciary and those involved. Oh, here we go. Mr. Shocket is not allowed to appear on live streams falsely depicting and mocking a judge. There's Doreen. That's Doreen Turner Inkles. Doreen Turner Stinkles. That's Pocket Rocket. That's Eddie Munster. And who's this one?
That's Mark Feather.
Oh, it's Feathers. Okay. Mr. Shocket's attempt to minimize his involvement in the nature of live stream published on 4/6/24 is directly contradicted by the content of the stream itself, which would broadcast to an audience of over 60,000 viewers. During the live stream, Mr. Shocket appeared alongside his co-counsel, Doreen Stinkles, former counsel Mark Feathers, and Larry Foreman, a.k.a. Eddie Munster, another YouTube client of Mr. Shocket's, and all appeared to be at Mark Feathers' home. Additionally, Mr. Shocket provided refusal to rebut his position that during this live he was able to discuss Judge D. Thomas's. However, this video was made on 4/6/24, and the order Mr. Shocket revised for Judge D. Thomas' recusal on appeal was 8/7/24. Thus, once again, demonstrating Mr. Shocket's disrespect towards the Florida bar by confusing the dates of this video with the date of the appeal order. Let me show the transcript. A very clear acknowledgement of active litigation. The very outset of the live stream, participants explicitly state their awareness of ongoing litigation. We don't want to put anybody in jeopardy because we have active litigation. We have active motions, as qualified Judge Thomas. We have a federal lawsuit that we can't talk about. These admissions make it undeniable attorneys knew they were participating in a public broadcast while actively involved in sensitive, unresolved legal proceedings. Consumptions of alcohol and appearance of intoxication. We've openly announced and displays and the opening and consumption of alcohol. Now I'm going to pour myself a glass of wine for this shit. Yeah, I'll get a drink too. Cheers to that. Somebody pass a bottle this way. The participants laugh and make light of the situation. The conversation.
Angel seemed like she was already toasted before they started.
Stinkles, she was tanked.
Oh yeah, it appears more than that, but yeah.
Because Judge Thomas is informal and irreverent. As the live stream progresses, reinforcing the appearance they were under the influence. Use of vulgar, inappropriate language.
Oh yeah, she's dropping F-bombs.
Vulgar language, further emphasizing lack of professionalism. Significant shit 2 days before trial. Shit you. Fucking shame on you. Promotion of client's case on YouTube channel. Participant acknowledged their YouTube presence and the attention the case is receiving. Fan is because just the week prior this went on and exploded on YouTube and the internet was watching. It wasn't just Jeremy's channel anymore. There's a bunch of other channels and you were like, uh-oh. Furthermore, the live stream reveals a pattern of disrespectful commentary and mockery directed at Judge Thomas's, with several statements and exchanges directly aimed at undermining his competence and the integrity of his procedures. Mocking the judge's handling of disqualification motions. Speakers repeatedly discussed the judge's denial of their motions, disqualified, suggesting incompetence or willful disregard. So he denies that in the February 14th, and that's the order. We're going to call his attention to the fact it's that this and itself is a basis of and whatever. Here, the casual whatever, after discussing legal basis of qualification, trivializes the seriousness of the judge's decision, criticizing the judge's delays and decision making. The group openly mocks the slow pace and perceived arbitrariness of the judge's rulings. How many days do we say that it took you to deny the first one? 21 to 26? Over 5 days? Over Christmas? It's under advisement. It's, well, we'll let you know. Whatever. Repetition and dismissive whatever show overt skepticism and disrespect for the judge's process, subjecting he's either lazy, incompetent, or indifferent.
Yeah, they kept going over that in the video. Doreen kept going over and over. She was just wasted, if you ask me.
Sarcastic ridicule of court procedures and orders. The participant uses sarcasm and banter to further belittle the judge's schedule and written orders. Must have capitalist, bold capital, yeah, bold capital, underline, maybe a bigger font, the page, but it was definitely, oh yeah, bold and capitalized. May even be a response size. I need to maybe screenshot, get it, oh my God. This exchange makes the judge's written orders an object of ridicule and debate his use of formatting if it were a joke rather than a judicial act. Implied accusations of arbitrary or vindictive scheduling. The group describes the scheduling of hearings in a way that implies the judge is either disorganized or intentionally making things difficult. February 28th, the afternoon, exactly when it's conflicting, all counsel and all parties. That's the scheduling order. It came right. That's the exhibit, and that's the third motion to disqualify. It's in there. Expressing disbelief and mocking unusual disbehavior. I don't know what to expect, but I ever see kind of bold, capitalized, text from a judge before. Statement suggests the judge's acts are not just unconventional, but worthy of derision. Direct link appearing in the live stream to a playlist depicting Judge Thomas's adversarial attorneys and adversarial litigant in active cases with them in a highly disparaging light. The live stream Mr. Shocket and others appeared in had a direct link attached to the access a playlist of highly disparaging content about Judge Thomas's adversarial attorneys and adversarial litigants. The evidence shows Mr. Shocket's knowledge and awareness of the out-of-court egregious conduct of his clients were partaking in as the playlist was published by his client, Larry Foreman. Conclusion taken together. These statements direct link to harassing playlists of the judge. The overall conversation style reflects the deep lack of respect for Judge Thomas's. Lawyers did not merely disagree with his rulings, they openly mocked his competence, imply arbitrariness or vindictiveness in his scheduling, use sarcasm, vulgarity, ridicule the court's orders and procedures. Such conduct goes beyond criticism, clearly seeks to undermine confidence in the judge's ability to fairly and competently preside over the proceedings. Based on the documented conduct from the live stream, the following Florida bar ethical rules have been violated. Rule 4-8.2, statement concerning judges and other adjudicatory officers. A lawyer shall not make a statement that the lawyer knows to be false or with reckless disregard as to the truth or falsity concerning the qualifications or integrity of a judge, hearing officer, or other adjudicatory officer, or a candidate for election or appointment to a judicial or legal office.
Good night, Ray. I hope you feel better.
Evidence. Live stream contains numerous statements mocking and denigrating Judge Thomas's, both directly and by implication. P.S. You kind of did this and this and this, and we're going to give you an opportunity. Third motion to disqualify, file 1 week later, whatever. It must have capitalists underlined. These statements taken together and with direct links to the playlist should disrespect and serious incompetence or lack of integrity on the part of the judge. Clear violation of Rule 48.2. Oath of admission to the Florida Bar, solemnly swear and maintain respect to the courts and justice, judicial officers, and abstain from all offensive personality. Evidence, multiple statements throughout the live stream display open disrespect, sarcasm, vulgarity towards the judge and the court system, violating the oath to maintain respect for the judiciary and abstain from offensive conduct. 4.8.4d, misconduct, prejudicial administration of justice. A lawyer shall not engage in conduct in connection with the practice of prejudicial administration of justice. Evidence, consuming alcohol on a live stream while discussing active litigation, mocking a sitting judge, using vulgar language, acting as officers of the court. All actions that tend to erode public confidence in the justice system and are prejudicial to the administration. Rule 4-3.5c, impartiality and decorum of the tribunal. A lawyer shall not engage in conduct intended to disrupt the tribunal. Evidence, the repeated public mockery of the judge's procedures, orders, and integrity, especially while litigation ongoing, undermines the decorum and impartiality expected of legal practitioners. Rule 4-1.7, conflict of interest, current clients. The lawyer shall not represent a client if your representation involves a concurrent conflict of interest. Lawyers appearing intoxicated, joking, and engaging in inappropriate commentary in a public forum about their own active cases could compromise their client's interest and the integrity of the representation. Summary. The
You're almost there, Rich. You're almost there.
Summary. The conduct evidence in the live stream violates several core Florida bar rules, especially those requiring respect for the judiciary, honesty, integrity, and maintenance of the dignity of the profession. Attorneys' public comments and behavior about Judge D. Thomas's and the ongoing litigation breach both the letter and the spirit of the ethical rules and the oath of admission. Mr. Shocket appearance on live streams with his clients resulted in mob attacks against an active judge in a pending matter. So this is what they have here. DeSantis removes Judge Thomas as the issue.
It is an article.
Yeah, that's their article. After Shocket's live stream appearance, one of the viewers who also had a YouTube channel issued a petition to remove Judge Thomas's, circulates petition to his audience of thousands of viewers, resulting in over 5,000 YouTubers signing the petition. And later, Judge Thomas recuses himself. Thomas is not the only victim of mob attacks that originated from Mr. Shocket's clients' live streams. 2 other pro se defendants that Mr. Shocket's clients were suing became targets of mob attacks originating from his clients' YouTube live streams. Michelle Preston, whom Mr. Shocket's client branded the name Lynette, had over 42 DCF calls made against her after Mr. Shocket's client, Jeremy Hales, went live encouraging his audience to report her for being a neglectful parent. Mr. Shocket even helped orchestrate a GoFundMe with his client, Jeremy Hales, to raise more to have someone try and remove her child from her. Leslie Federico was attacked by Jeremy Hales and other YouTubers and their audience after Jeremy Hales published where she was working as a school teacher, resulting in hundreds of calls made to the district expressing concerns over her character, resulting in a resignation from her job. Affidavits can be provided upon request from Michelle Preston and Leslie Federico's. Mr. Shocket continues to allow his law firm to appear on GoFundMe crowdfunding that directly benefits Mr. Shocket financially. With knowledge, this crowdfunding campaign falsely depicts the nature of the lawsuits, mocks the judiciary, and incorrectly reflects the legal fees spent out of pocket. Mr. Shocket admits that his clients initiated a GoFundMe campaign, claiming they're entitled to do so. However, this position fails for multiple reasons. First, Mr. Shocket says legal fees are sought to pay a balance owed. However, he fails to state the campaign states these fees have already been paid out of pocket. This is relevant because donors are expected to mail payments to Mr. Shocket's law firm. However, there are no disclaimers as to what will be done with access to funds received by Mr. Shocket, nor whether this money is being placed in a trust for future fees. It's unknown how much money Mr. Shocket has received today from the public because there's no way of tracking what has been sent to him. It is known that his client received direct donations of over $35,000 directly from the GoFundMe and over $130,000 directly donated during his client's live streams. Second, Mr. Shocket is aware of exactly what this crowdfunding campaign states through notices sent to him. Yet he takes no measure to disassociate his law firm name with this crowdfunding campaign. Why? Because Mr. Shocket benefits financially. While he attempts to play clueless to what's going on, Surely, if he was receiving money from this campaign, which the campaign directs payments would be sent directly to Mr. Shocket, it would seem ethically he would inquire as to how the campaign presented with his name attached. Further evidence of this is Mr. Shocket's donation of his tie that his client auctioned off to raise money. I remember that one. Third, Mr. Shocket allows himself to be a financial beneficiary to a campaign that is falsifying facts to the public for donations, which constitute possible crowdfunding fraud. Additionally, he has allowed himself to be part of a campaign that has published false and disparaging statements about judges and attorneys as part of a GoFundMe description. Yet Mr. Shocket continues to associate his name with this campaign. Facts and evidence on this page have previously been submitted to the Florida Bar in my initial complaint. The link to the GoFundMe campaign was previously provided in my initial complaint. Violation of ethical rules. Standard will be implicated if a lawyer, Mr. Shocket, knowingly allowed his law firm to appear on a GoFundMe campaign, directly benefits him financially, falsely depicts the nature of the lawsuits, mocks the judiciary, misrepresents legal fees spent out of pocket. 4-8.4C, misconduct. A lawyer shall not engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Application. Knowingly allowing or participating in a crowdfunding campaign that falsely depicts the nature of lawsuits or misrepresents legal fees constitute dishonesty and misrepresentation. Florida Bar v. Kupke, the Supreme Court disbarred a lawyer for willful lack of candor and intentionally misleading statements regarding financial matters. 8.4D, conduct prejudicial to the administration of justice. A lawyer shall not engage in conduct in connection with the practice of law that is prejudicial to the administration of justice. Mocking the judiciary or using public platforms to underline respect for the courts is prejudicial to the administration of justice. Example, in Florida Bar v. Patterson, the court suspended a lawyer for making unfounded accusations about judges and for conduct damaging to public confidence in the judicial system. Rule 4, 3.3, candor to the tribunal. Lawyers shall knowingly make a false statement of fact below to a tribunal. Application. Well, this rules the specific statements made to a court. Public misrepresentation about ongoing litigation can be seen as undermining the integrity of the process, especially when the public is misled about the nature of the case and the court's actions. For example, the document repeatedly references the importance of candor and the harm caused by misleading statements, even outside the direct court filing. Conflict of interest, Colin Klein. A lawyer shall not represent a client to substantial risk. The reputation will be materially limited by the lawyer's own interests. The crowdfunding campaign directly benefits Shocket financially, and he's representing clients or related matters. This creates a conflict of interest that must be disclosed and consented to in writing by the client. Example, Florida Bar v. Patterson, the court found a conflict with the lawyer's personal and financial interests conflicted with those of the client. Professional expectations and oath of administration. Text. Florida lawyers are expected to act with honesty and integrity and civility in all communications, including online and public statements. Application. Allowing or participating in a campaign that mocks the judiciary or misleads the public about legal proceedings violates these exemptions. Example. The document notes that unprofessional conduct includes substantial or repeated violations of the oath of admission, creed of professionalism, and professional expectations. Actionable example, implementation. If a lawyer is aware that a GoFundMe contains false statements about the nature of lawsuits, mocks the judiciary, misrepresents legal fees, and directly benefits the lawyer financially, the lawyer must immediately request a removal or coercion or correction of the false misleading content, disclose any financial interest of the client to obtain written consent if there is a conflict, abstain from practicing in or benefiting from the campaign until it complies with all ethical rules, refrain from any public statement that undermines the integrity of the judiciary or mislead the public. Right. Florida Bar v. Kupke, disbarment for willful lack of candor, abuse of legal process. Florida Bar v. Patterson, suspension for unfounded accusations and conduct damaging to public confidence. Florida Bar v. Patterson, conflict of interest for disparaging statements about judges. In summary, they describe conduct that would violate multiple Florida rules and professional standards, specifically rules 8.4, 8.4C, 8.4D, 3.3, 4.17, the general professionalism exceptions. These rules are supported by recent Florida Supreme Court disciplinary cases. Mr. Shocket's concerning history of criminal fraud and issues of candor. It is extremely concerning that Mr. Shocket continues to hold a license and practice law in the state of Florida concerning his history and criminal fraud and issues of candor. Arkansas Supreme Court, in the case of Shocket versus Arkansas Board of Law Examiners, 1998, addresses Randall Mark Shocket's denial of admission to the Arkansas bar. Key points: Shocket met the educational and examination requirements for admission, denied by the Arkansas bar due to questions about moral character and fitness. The board found Shocket committed insurance fraud and perjury related to his previous dental practice in Missouri, where he billed for services not rendered and practiced dentistry on a suspended license. Shocket admitted that this past misconduct, but later denied responsibility and blamed his attorney, showing a lack of acceptance of past wrongdoing. He also provided false, misleading, or incomplete answers in his bar application and related professional license applications, including failing to disclose his securities license and prior disciplinary history accurately. The board determined Shocket lacked the necessary honesty, truthfulness, and candor required for admission to the bar. The court upheld the board's decision, emphasizing that evidence of rehabilitation is important, but must include candor about past misconduct. Since Shocket failed to demonstrate such candor and accept responsibility, the court affirmed the denial of his bar application. In summary, the ruling stresses the absolute necessity of honesty and full disclosure in the bar admission process and finds that Shocket's past misconduct and lack of candor rendered him unfit for admission. Arneson Webb, PA, representing plaintiffs Tory and Gujana Skyers, is an insurance dispute against Property University and Casualty Company, filed a motion to withdraw as counsel due to unethical and improper conduct by Randall Shocket. Key points from this document: Arneson Webb is a law firm specializing in insurance first-party litigation in Florida, representing hundreds of clients against insurance companies. Shocket's engaged in a pattern of unethical behavior, including repeatedly soliciting clients improperly by using information from public adjusters to steer clients to his firm. Shocket has a history of legal and ethical violations, including a prior license suspension for insurance fraud, perjury related to his past dental practice in Missouri and Arkansas. The document details multiple cases where Shocket appeared as co-counsel without proper notice, filed liens improperly, and disrupted ongoing cases. Shocket allegedly orchestrated termination emails to clients to discharge their prior counsel and switch his representation using similar language and tactics across multiple cases. Filing references a pending Florida bar complaint against Shocket for violating professional conduct rules. There are allegations that Shocket used confidential information allegedly provided by a mole employee from Heritage Insurance to extort money and inflate claims, leading to a lawsuit by Heritage against Shocket. The document includes exhibits and correspondence showing aggressive and threatening behavior by Shocket and associates with public adjusters and opposing counsel. The law firm seeks court approval to withdraw as counsel and for the Skyers and due to Shocket's interference and unethical conduct, and request liens and fees for expenses involved. Overall, the filing paints a picture of an attorney with a troubled professional history, accused of unethical solicitation, manipulation of clients, misuse of confidential information, causing disruption and ongoing insurance litigation handled by Arneson Webb. Published article from the Sun Sentinel reports that a lawsuit by Heritage Property Casualty Insurance, a water damage contractor, Titan Restoration, and attorney Randy Shocket accusing them of using a mole inside Heritage to steal confidential claims. The facts are an unknown Heritage employee dubbed Jane Doe allegedly confidential claims to Titan and Shocket. Titan used stolen
Yes, yes.
What?
Richard, you're doing great, man. It's almost over. I think you got one page left. You can just skip this. I added everything I could. There's more, but it's pretty big.
Titan used stolen information to steal water damage repair business from Heritage approved contractors by contacting policyholders first, submitting inflated or falsified invoices. The scheme involved bribery, kickbacks, and fraud, driving up insurance losses, enforcing rate hikes. Titan employees inflated report work hours and billed for expenses not performed, according to a deposition by a former Titan employee who later quit to expose the wrongdoing. Shocket reportedly used stolen confidential information to pressure Heritage into paying higher settlements and legal fees, showing stacks of claim files and mediation. Heritage often seeks to order to force Shocket to return the files and reveal the mole's identity, but the judge has not yet ruled. Shocket denies wrongdoing, complains the disclosure was lawful under mediation, whistleblower protection, and calls the lawsuit a sham pleading. Heritage intends to reveal the mole's identity once known. Overall, the article exposes a high-profile insurance fraud and extortion case involving insider leaks, inflated claims, and aggressive legal tactics against Heritage Insurance. A report from the 15th Judicial Circuit Grievance Committee, C, for the Florida Bar regarding minor misconduct by attorney Randall Mark Shocket. Shocket represented clients in the insurance matter following expert adjuster Daniel Loria. Loria recently filed a lawsuit against Pat Goins, public adjuster company owner with whom Shocket had a long-standing relationship for unpaid commissions. During a deposition of the case, Shocket questioned and challenged Loria his own expert about the commission contract Laurie was suing to enforce. Shocket insisted Laurie answer questions without Lauria's lawyer present, despite knowing or should have known that Laurie was represented by counsel in the separate lawsuit. That violated Florida Bar Rule 4.2a, which prevents a lawyer from communicating about the subject of representation with a person known to be represented by another lawyer without that lawyer's consent. Grievance Committee accepted Shocket's admission of minor misconduct and recommended he receive an admonishment. The admonishment warned Shocket that such other conduct discredits the legal profession and must not be repeated. Costs totaling $1,273.10 were assessed against Shocket. In short, Shocket improperly communicated that with a respected party without counsel's consent during deposition, resulting in a formal admonishment for violating professional conduct rules. Conclusion. This evidence presented demonstrates that Mr. Shocket's unethical conduct is not isolated or a matter of the distant past, but rather a persistent and troubling pattern that spans decades and continues today. From his early acts of fraud and lack of candor in Arkansas and Missouri to ongoing complaints, bar admonishments, and allegations of misconduct in Florida, Mr. Shocket's repeated disregard for ethical standards has become a defining feature of his professional life. This ongoing behavior poses a significant threat to the public and integrity of the legal system, making his continued licensure a leading issue in the harm being inflicted on clients, colleagues, and the broader community. I respectfully request the Florida Bar take immediate action against Mr. Shocket to prevent further damage to the public. Witnesses willing to provide affidavits to support the rebuttal: John Cook, Bruce B. Matzkin, Marley Hughes, Patty DeAgostino Plummer, David Helm, Bobby Kesey, David Michael Teschendorf, Raymond G. Bonebreak, Michelle Preston, Richard Luthman, Leslie Federicos, Michael Federigos. Evidence available on request: videos, transcripts, deposition records, and police records. Signed, Lisa Lee.
Thank you, Richard. Wow, right? I tried to get everything in there that I could, and there's more, but as you see, it is really long, and I thank you so much for reading that because my eyes are just so bad.
I'm going to pour myself a stiff one right now. I need a stiff one, I think. Woo! Holy shit.
Isn't that crazy?
Yeah. That's good, though. It's a lot. It's good, though. It's really
It's
good.
a lot. It is definitely a lot.
But
you know what? There's so much in there.
It's dense. That's why. It's a lot of stuff. Yeah.
Yeah. Yeah. And it's just like, you know, I tried getting everything that I could in there, including, I mean, that's all the harassment, all the points, everything that I know, you know what I mean? And it was a lot of work. It was a lot of work. But I think, I actually think it's pretty good. It is truth. There's nothing but truth in that. And Facebook groups will be going crazy. I'm sure they will, Marla. But, you know, I'm sure they're going to try and copy it. Because last time I showed something that I knew none of them had, you know, they tried to crop it and make it look like it didn't come from my show, which it did because I was the only one that had it. And I can tell you right now, I'm the only one that has this. So if they do copy it, you know, that would be them, you know, copyright infringing. Again. But yeah, so Rich, you're right.
Yeah, I'm okay. I'm good.
That's like, there's just so much in there, you know, and I felt, you know what, if you want to play the victim, dude, I'm going to show the bar that you are not a victim. You know what I mean? With everything you've done and how you treated people and how you like misled the courts in so many different ways and for so long in so many different cases, let's put it out there. Let's let the bar know what's going on, you know? And everything's there, you know, pretty much everything's there. I don't know. What do you think he's going to respond? I don't know if he can respond again. You know?
What I think he's going to respond, I don't think he gets another response, but I think that, you know, to answer Leslie's question, what do I think? What's my take? I think that you have it all in there. And it's like they can't ignore it. They're going to have to really look at this and investigate. That they have to have some very serious questions they have to ask, especially about some of the stuff that he said that you disputed and contradicted with evidence here. You said, "Oh no, I have the evidence that showed he lied." Like he lied in the thing we read before. You know, he said things that weren't true, and you show very clearly, no, this is not true. What he said is not true because of X, Y, and Z. And that's like the death knell for a lawyer when they catch you in a lie. You know.
No, no. It wasn't worth putting Michelle wrong. Wait, Lisa, it wasn't worth putting Michelle wrongly sent the text to Jerm and Jerm talking to Shocket not long after Jerm putting a complaint. Uh, well, I know that Michelle has a bar complaint too, so Michelle can literally tell her part of it as well. She's got more to tell than I do. You know what I mean? I mean, we're all directly involved, but the stuff that's been done to Michelle is absolutely insane. And I'm pretty sure that she's going to talk about her depot, or she should. He said Bruce confirmed Randall was at the depot. Yeah, Bruce did. There was they had a conversation via email. Randall sent them the link. Bruce went to the link and nobody was there. It was just Bruce. And he argued with him like that. And he knew that Randall was just trying to say that so he could charge legal fees. And I attached the entire conversation to the bar. So, you know, this was a lot of work went into this. I'm proud of it. And I mean, I wish I could say more, but it was a lot. It was a lot. Rich, you need a drink?
I do. I need a drink. You know what it is? You know my problem is I got to go tomorrow morning at like 10 o'clock for a blood test. So I don't know if I want to have a drink right now. So I'm like, ugh. I'm supposed to go like fasting. You know when you go fasting? But knowing me, like, you know, I'll forget in the morning and have some. But I'm going to try and be good. I don't think I'm going to have a drink. I think I'm going to be good. I'm going to drink water and go to bed. That's what I think I'll do.
Yeah. So did you want to talk about anything from your show today?
Well, what do people want to hear about? I got kind of cut off. What do you think people want to hear about more than anything else?
Well, I think they want to hear about you, you know, the rest of your filing that you didn't really get to, that you kind of sped through.
Oh, the long one? The one about the one for, let me see. I'll put it up. Hold on. Let me get it.
Yeah, there are many other bar complaints pending against Shocket. Yeah, there are. And there is more coming.
All right, wait.
Here, I'll remove my thing for this because
There's
this is
one,
yours.
right? Reasonable accommodations. That's one. So I'll put all three of them up so we can talk about them all. This one is motion to strike. This is when Randy was lied. We'll do that one, I think. That one's an easy one. And then this one is my motion for a reply. Okay, so let's start here. Let's start with the one for where Randy lied. Because we're on the topic of Randy.
Yeah.
Right?
Yeah.
And so this is about Randy lying. That's what this motion's about. I'll go to the end actually and show everybody what it's really about. Okay, let's show the documents. Here it is, right here. This was
I'm not going to interrupt you at all.
This is the email that I sent to him, right? Hey, Randy. And I sent it to Randy Shocket, the Shocket Law Group, Doreen Turner Stinkles, and this Emma DeGamo, who I guess works for him. And I copied the Florida Bar. Smiles at Florida Bar. That's a funny name, Smiles, right? W. Mulligan, L. Williams, ACAP Intake, and R. Berman. Hey, Randy, a.k.a. Randall Shocket. I write regarding the statement of service on page 30 of Plaintiff Jeremy Hill's June 16th opposition by motion for order to show cause. So I put in a motion for the court to put a show cause order in, right? To basically say that Jeremy Hales said that the Exhibit A, not this Exhibit A, but the Exhibit A in the case, that is the video, the big video that he terms, this is what Jeremy calls it. It's Jeremy Hales having sex with a journalist. And I created a video of Jeremy Hales having sex with a journalist. And I said, well, if there's no point in that 60-second video where Jeremy Hales is having sex with a journalist. So please identify me the frames in which Jeremy Hales is having sex with a journalist. What's the timestamp? What are the seconds from 0 to 60? Which ones is he having sex with a journalist? And he either he can do that, or that is a false statement. Jeremy Hales is having sex with a journalist, and therefore it has to be taken out of the complaint. And if it's taken out of the complaint, then the whole claim against me fails, and so the case is over. Well, look at what Randy Shocket did. He did what's called a certificate of service. I hereby certify. So this is Randy Shocket certifying that on June 16th, I electronically filed the foregoing document with the clerk of court using the CM doc. I also certify the foregoing document is being served on this day on all counsel of record via email to the service list below. Right? And look at that, Richard A. Luthman. Well, what did I say? I have no record of receiving that from you on June 16, 2026. And I said, Rule 5 requires that you send it to me, right? Your certificate represents it was served on me on June 16th. I'm asking you to provide me proof. Please send me one of the following. Look what I asked him. To send the email header, a CM ECF notice showing that I was served through the court's electronic filing system, any written consent or court order, any other documentation. The certificate of service is inaccurate. Please advise whether the plaintiff will promptly file a corrected certificate identifying the correct date and method of service. Please respond by close of business. There's Trump. Well, look what happens. The next day, look at what douchebag sends me. He sent me this email. Wednesday, June 7th at 9:33 p.m. A full day later. He writes this. He forwards this here. 1:25 notice will be mailed via USPS, will not be electronically mailed to Richard Luthman Jr. So it won't be electronically mailed, right? That's what it says. And he forwards me what he got the day before at 1:27 p.m. on June 16th, which says down here, will be mailed via USPS and not electronically mailed to Richard Luthman, right? And you go back up, and what does it say? I hereby certify the foregoing document is being served on this day on all counsel of record via email to the service list below. Doesn't say anything about being mailed by regular mail. It's by email.
Right.
So I'm telling him, fix it. Fix your certificate of service. Say Richard Luthman was served not on June 16th. He was served on June 17th, right?
Yeah.
But he didn't actually serve me with the papers. He sent me the thing that it was going to be mailed to me, right? So it was going to. So it's like a lie. This is a lie. It's a big fat lie right here.
Yeah, he did it to me like 3 times.
I'm not going to let him get away with the lie. Yeah, it's a big fat lie. We're not going to do that.
That's a certification. That's a certification to the court.
He lied to the court, and he's a lawyer. He's not supposed to lie to the court, and so it's a big problem. So that's what this motion's all about right here. This motion's a motion to strike. Get rid of the affidavit of service and just reset the motion at this point. Let's that or just strike the response and make me win by default because he's a scumbag, and that's what he did. He really shouldn't be. Doing all this stuff that's so shady as a lawyer. And that's the whole point. And it shows more and more and more a pattern of his just poor behavior. So I went through the whole thing, and it's all here. I went through it before and what he said, and I think it's pretty clear what he did. He said that he served me on the 16th. I caught him on the 16th, and he didn't have it. And he didn't apologize, and he didn't try to correct it either. And that's the big problem. When he doesn't try to do it, it's inaccurate, and he didn't try to do anything to fix it. Right? He forwarded an email that doesn't cure it. And then the big thing is the defect. I'm a pro se non-ECF filer, so I'm not getting the emails. But the big thing is here. Plaintiff's failure to correct the certificate after notice warrants relief. Once I tell him, hey, dude, you messed up. You put in something false. You got to fix it. And he thumbs his nose. At that point, the court has to do something. Or else nobody has any respect for the court at that point.
Yeah.
You could just put it, if a lawyer could put in false shit, how come anybody else can't? I'll put in some false shit. I'm pretty good at putting in false shit. Fuck. Why can't I do that? Why do we have to tell the truth if lawyers don't tell the truth? Right? So that's this first motion. Then that's what we're dealing with in that first motion. The next motion.
I think you have every right to point that out. And because even you're pro se, and pro se people have rights regardless of whether the court looks at it like they're not as up to the standard as lawyers or something like that. I think that's like so rude. I mean, it may be true, but you still have to point out the shadiness of everything.
Give me 1 minute. I'm gonna get another drink.
All right. Wow, guys, it's a lot of information tonight, huh? What do you think? Whatever her name is, just lost her chance for this highest Supreme Court because of the date. Wow. I'm telling you, like, people lose cases all the time on little technicalities, and, things matter. When you got lawyers lying and you can prove it, I mean, I think it really, really, is important to point things out like that. Good night, Dusty. Lawyers tell the truth. I know, but you know what the thing is when what Shocket does is he throws little things in there, expecting that especially pro se defendants are not going to catch, and they don't know any better. You know what I mean? And that might be true in some cases, but you know what? Some people here are not like that, and we've been paying it pretty close attention. They're not dealing. These defendants in this case are not, stupid people. Let's just say we're all pretty smart.
Okay, I'm back.
Thank you, Lori J. Welcome back, Richard, and thank you again so much for reading all that.
No problem. So this is the order.
Get the chat.
This is the order from the other day. Okay, and this is very important. Why this is going to be coming in here. And this is the motion that Volpe had his panties in a bunch about earlier today.
All right.
This is the order that was written by Hankel. Look at what it says: Jeremy Hales versus John Cook.
Well, yeah, they should be taking that out.
he's been out of the case for 2 months, 3 months already. Since April. So it's all bullshit. John Cook. That's a mistake. He orders the overruling the objections. Lupin filed objections. Lupin filed additional objections, include a baseless suggestion to the clerk's office mishandled the original objections. Perhaps the new objections just because the opposing parties infiltrated the clerk's office, or perhaps bribed clerk's employees. The assertion is detached from reality. Now, if you were on my show before, you saw I played the video several times of Mr. Coop, right, and the fly on the wall.
Yeah,
they called me Ace. They had somebody in the courthouse feeding them information. This
according to George, yeah. And there was also someone in the chat claiming to be with the name fly on the wall.
This is not the assertion is detached from reality. It's actually based on the reality of the Hales ecosystem and the chat. And I'll show you. Actually, I'll put this up real quick, and you can put it up for me. We'll have to take that down, but I have the sweet fly on the wall. Actually, we want to play the video a little bit or not?
No, I'm not gonna play the video.
All right. Let's see which one this is. I'm gonna put.
You can put the screenshots.
Yeah,
on there.
Screenshot. All right, the sweet fly on the wall. Put the sweet fly on the wall screenshot.
Yeah, it's crazy to think that. First of all, you're in Levy County, right? And there's a lot of people that work at the courthouse that even when you just walk in to drop off paperwork, they're fans of Hales. People in Otter Creek know the people that work there. And they know that these people are friends, and fans of Hales. So it's literally like how could you even possibly deny that? Like when you go to drop something off, they can literally they know the case, they know the people involved. When you call there, like when I called to ask about sending Ray's you know response in there, they knew the whole entire case, and it's like put it this way. There are people in Otter Creek that are friends with people that work there, and I'm not talking Michelle or John, but there are other people who are friends with them that work there, and they fully know that they're Hales fans. So it's not crazy to think that one of these people online was talking to Georgie or Coop. You know what I'm saying?
Yep.
It's not crazy to think that, as much as it seems like it could be, or like, no way. But I can see a judge being upset with the accusation of it, that somebody in his court or in his chambers would do it. But he doesn't understand. It's a really, really small area, and all these people are so involved in it because, believe it or not, it's like big news in that town.
Yeah.
So sorry, go ahead.
So that's
you want me to add? Okay.
that sweet fly on the wall. Now put the other one up. And say that could be interesting. Our little fly on the wall is the one who hooked me up. You see that's one of the things. The judge is currently responding, and they have another update before. So they have the inside information right here. And if you look at my chat from before, we have all that information up there. And I'll pull these down. We'll go back to the whatchamacall, to the there we go. Now we're here, and this is the order. It's saying the assertions detached from reality. Now this whole motion is about the detached from reality. Okay.
Yep.
And so this is about my motion for procedural accommodations, right? What do I want? I want practical procedural safeguards so the case is litigated on the merits without forfeiture, waiver, sanctions, or adverse rulings based on functional disadvantage be created by my pro se status, lack of CM, ECF, that's e-filing access, documented mental health history, known cognitive and emotional impairments, and the court's own recent characterization of one of his assertions as detached from reality. The judge has said Luthman's detached from reality. How can I get held to a higher standard if this guy says I'm detached from reality? Right? So that's the argument. And here's my certification with Hales, and I asked for modest procedural accommodations. Why? Because the judge says I'm detached from reality, right? And I should get them, right? I want an advantage. I don't want no special privileges. I just want the court to basically treat me with respect and not treat me to the standard of an attorney of record or the standard of an attorney, because I'm cognitively impaired and detached from reality because the judge said so. Think about that. Now, I will tell you one of the big things that's there is, and we saw detached from reality, but the big thing that's there is Germ's own statement, right? What does Germ call me? He calls me paint chips.
Yep.
Right? So if I go and show that, plaintiff has publicly portrayed defendant as impaired. Plaintiff Jeremy Hales has repeatedly referred to defendant as paint chips on YouTube broadcasts, apparently suggesting that defendant suffered brain damage from eating lead paint chips, and at times implying defendant continues to do so. Defendant does not adopt plaintiff's insult, but plaintiff's own public characterization demonstrates that the plaintiff, Jeremy Hales, and his counsel, Randy the Pocket Rocket Shocket, cannot credibly claim surprise that the defendant suffers from apparent cognitive, emotional, psychiatric, or behavioral limitations affecting limitation conduct. If you're going to call somebody paint chips, you're going to say he's damaged. Don't be surprised he says I'm damaged. Plaintiff chose to sue the very person he publicly portrays as mentally impaired. Having made that choice to sue, plaintiff should not be heard to demand that defendant now be treated as though he were a licensed attorney with unimpaired judgment, full electronic access, and professional litigation capacity. I'm not that. And by Jeremy's own admission, by his own statements, I'm not that. He's held to what he's called me. And the big thing is, Hinkle's called me detached from reality, right?
Yeah. Yeah.
But I'm not detached from reality. Publicly available Hale's ecosystem material includes a transcript in which YouTubers discuss a fly on the wall, allegedly providing real-time information about a judge's current activity. In that exchange, Krista Gurley states that our little fly on the wall said the judge is currently responding as we speak to the documents. The latest states, I can't tell you everything because we can't be getting our fly on the wall in trouble now, can we? Mr. Coop responds that, as far as I know, we're the only ones that have this ace, and says the fly will never be named. Defendant does not ask this court in this motion to adjudicate who's the fly on the wall, but whether the speaker was exaggerating, or whether any courthouse employee or court adjacent person actually provided information. But the public statements show why my concerns, the defendant concern, was not manufactured from empty air. They
Right.
show why the filings and presumptions should be addressed through careful procedural management, not sanctions first treatment, not labeling, detached from reality, right?
Yep.
If my reasoning was detached from reality, if that's what the court believes, then I should get procedural accommodations. Or else the court should correct itself and says, well, maybe he wasn't detached from reality, which is probably never going to happen.
Right.
Okay. So let's see.
But
I
at
have the
least you
ADA.
proved that there was a reason, that it's been already said that. You know what I mean? It was put out there that there is someone working and telling everybody what's going on in the chambers there. You know, you
Right.
proved it.
That's right. And so let's see.
Whether it was true or is true or not, you know, but it's been, that's what's been put out there.
That's right. So there's the standard of attorney. The detached reality reinforces the need for the accommodation. The June 15th language is important. If defendant's assertion was merely wrong, the court could say it was unsupported or insufficient. But the court went further and said the assertion was detached from reality. Okay, the public fly-on-the-wall transcript demonstrates the defendant's concern about court-adjacent information flow was not without any factual trigger. But even assuming the court rejects the defendant's inference, the court's language points to an accommodation issue. If a litigant's reasoning is viewed by the court as detached from reality, then procedural safeguards are appropriate. The court should not simultaneously characterize the defendant's reasoning as impaired and then hold him to the functional standard of someone that's fully able, or especially a fully able attorney.
Right.
The fly-on-the-wall transcript does not require a finding of misconduct, but it shows defendant's concern it was not fabricating. I'm not asking the court to find anyone infiltrated the clerk's office or bribed anyone. I'm not asking the court to sanction a third party based on the transcript. I'm not asking the court to resolve to identify the fly on the wall. The transcript matters for the narrow reason that it shows the public Hale's ecosystem participants were discussing a person described as fly on the wall who had real-time knowledge. The judge is currently responding to filings. The speaker described protecting that person's identity and referred to the source as an ace. Anybody who sees these statements and then raises the concern about court-adjacent information flow may be wrong in the influence, but the concern is not necessarily imaginary, right? The distinction matters. It weighs punitive treatment and supports measured accommodation. Then I ask for e-service, and I ask for additional time to cure my filings, and I say that there's be no prejudice to the germ for all this stuff, and then I cite the cases, I ask for all this stuff here, and that's the motion, right? That's the motion. I think I showed them that that's what's there. Now I have a whole declaration here where I talked about it, and I went through everything here very specifically. You know, Krista Gurley, Mr. Coop, our little fly on the wall, just let me know the judge is currently responding as we speak to the documents. Our little fly on the wall want to hook me up with the documents first today. I can't tell you all everything because we can't be getting our fly in trouble now, can we? As far as I know, we're the only one that's have this ace. That's what Mr. Coop says. The fly will never be named, right? So that's how these people go. They got this fly on the wall. And I'm not detached from reality. It's a fly on the wall. You know, I have to believe that they have somebody that's real inside information inside the courthouse.
Yeah.
And I have the exhibit list of the transcript, the live chats, and the excerpts and everything else. So This is what it is. It is what it is. It's all in this document. It's going to be all here for Hinkle to take a look at. Probably Belitho first, but I have the fly on the wall right here, Mr. Coop and Chris
Do you
Gurley.
think he'll try to do anything about who Chris Gurley is? And
I don't think they're going to care. I don't think these people care. Okay. Then the third one is the limited reply. And the limited reply is pretty easy. He said before I couldn't file a reply because it wasn't extraordinary. I'm saying, yeah, it is extraordinary. Basically, it does three things. Raises new procedural objections, recasts the challenge factual representation as a semantic dispute about manipulating media, and material mischaracterized defendant's declaration as an admission. What does that mean? There's three different things that he does, and I'll go through them real quickly. I don't want to bore everybody with this other stuff. But he lied. Jeremy Hales lied, and so did Randy Shocket. Lied 3 times. Okay?
Mhm.
Here we go. Where is this here? The first one. Where is this? Here it is. Plaintiff's motion challenged the specific factual representation. This is my motion. Plaintiff and counsel represented the court the challenge video depicted Hales engaging in oral sex with a journalist. That's what Jeremy Hales said in his complaint. His amended complaint. His complaint that's there, or the third amendment, whatever it's there, the third amended complaint. Jeremy Hales engaging in oral sex with a journalist. Right? But he didn't talk about engaging in oral sex with a journalist. He talks about digitally manipulated injury, deep fake, satire, parody, all this other crap. Okay?
Yeah.
Right? I had a very specific issue. Did plaintiff and counsel repeatedly present as fact that the actual video depicts Hales engaging in oral sex with a journalist when the video doesn't show that? That's what I said.
Right.
They lied and said that Hales engaged in oral sex with a journalist. The video doesn't show it. So I asked him, where in Exhibit A? Plaintiff should be able to identify the timestamp, frame, or portion of Exhibit A that depicts Hales actually engaging in oral sex with a journalist. That's number one. Right? Do you think that's like reasonable, Lisa?
Yeah.
It will save us a lot of time, right? That's
Absolutely.
number one. That's issue one. Issue two is he says there's an admission. I admitted that the video contains edited, satirical, composite, manipulated, otherwise altered media. Right? I never said any of this shit. He's making it all up. Right? The only thing I said, right, to the extent that it contains edited, or said the plaintiff complains about edited, satirical, composite, manipulated, or otherwise altered media, that is not the same thing as an actual video depicting Hales engaging in oral sex with a journalist. If there was satire, that's satire. It's not Hales engaging in oral sex. Oral sex is very specific. Oral sex with a journalist is even more specific. Satire, manipulation, altered media, those are very, very different things. So, and then the third part, and I have them all three here, is number two right here. See number two? And this is the technical legal point that he says you filed the motion, but you need to do this, that, and the other thing before you file a motion. No. This is a motion under Rule 11C3. I didn't file it myself. That would be under Rule C2. I filed it under C3 because the court can decide whether or not to show cause. I don't have to decide. The court does. And so I don't have to. It's not a motion that I have to do the motion stuff for. It's a little bit different than the other stuff. So that's the basis of this motion. Okay, that's what this motion is. Okay, and this is all three of these motions. That they're a liar. They lied in this one. They lied 3 different times, and I need to put a reply in. So we'll see what the court does. I don't know what they're going to do, but that's what we got going on. That's what I filed. This is all on the docket now. It's sitting in there. They're going to be talking about this the next few days.
Yeah.
Right?
Yeah.
So,
Lying about it all. Good night, Julie. Yeah, it's just amazing how much they lie. Like, I don't even understand why he's even still going through with this. This is ridiculous. You know, he's been proven to be a complete moron in the court. Everything thus far has been dismissed for failure to state a claim. Okay, so it's dismissed with prejudice. I mean, this stuff here is like it's a circus. And one of my things is like with a lot of the stuff that you're pointing out how much of a circus this is. You know, so like when Michael says things like, you're entertaining it, you're doing what Germ does, or whatever. In a sense, like, yeah, you're trying to prove to the court how much of a circus this is,
Right.
And I think you should be doing that, and then you should be pointing out the lies, and then you obviously fight the accusation. It's not revenge porn, and I don't know. Maybe they thought this was going to turn into like this big case. Like he thought this was going to be like national news, Maybe he thinks this is going to turn into like a Larry Flint versus Hustler thing. I mean, he thinks he's that much of a celebrity that's going to be that big of a deal,
He's that fucking delusional. He's a delusional bastard.
Yeah. Who's the one that's fucking, got this whole like crazy ass mindset? It's them, And Shocket don't care. Shocket's making money off him. He'll file anything.
I don't look. You saw it in the very beginning, though. The original opening papers I put in, Shocket responded. It was 30 pages long. Yeah. I just put in 3 more things. He'll put in another 90 pages, and he'll get billed for it. That's 120 pages in the last couple of weeks. He's gonna have to put in. I think Jeremy's gonna get. How much do you think he gets a page? $500 a page, right? Or 50 grand over here. He's gonna get paid 50 grand for this shit.
Oh, Lori J. Well, I gave it back to him in his, in the rebuttal. I'm not sure he gets to respond, but he's got 30 pages of shit. He's got to.
I'm talking my stuff.
I know. But I gave it back to him.
Yeah, but he had to read that, and he's got to figure out what to say. You're right.
Yeah.
So
yeah,
he's going to be billing the shit out of Jeremy for a lot of work.
Yeah. Yeah. But and his stuff it's fluff. It's all fluff. I mean, just when you look at the amended complaint, when he added you, it was ridiculous. Starting with defamation, and then the torts that he used was just absolutely insane. Absolutely insane. All lies. And now, like, he's taken this satire and parody thing that you have and turning it into revenge porn, and they're all pissed off. What's the difference? Why are they allowed to do satire and parody? They do it all the time.
Of course.
And actually not necessarily Jeremy, because he doesn't put like he's put a couple of things that they posted on, like certain things that like Flippin' Adventures did, like songs or whatever. But you got like Megan and Tug who's doing that constantly all the time, and she's the one that's all pissed off about it. And that Jeremy is just using it as a reason to sue you. He thinks it's a legitimate reason, So it's just bullshit. I mean, I got videos of Jeremy talking about fair use and how it's not fair use, it's stuffed. But now he'll sit there and say it's fair use. It's fair use, Like I wish Megan would see what the video of him talking about how it's stuffed. Because what she did to me, you got to hear what he had to say.
You got a great case though. That's the thing.
Yeah. So. And so when did the court receive this?
Today. Well, when we were on the air, at 5 o'clock, this stuff started getting uploaded.
Oh, okay. Right on.
So they'll be talking about this tomorrow morning on Shizzy No Nuts and on Mr. Hoop and all the rest of them. They'll be talking about this shit. And then maybe Squid Pro Quo, that little one, that she'll be having on hers too.
She's all of a sudden getting in the middle of everybody's shit. Usually she's stuck to like 1 or 2 things, but now she's like, spreading herself, because she feels she needs backup. So she's going to like Megan and all these people to get her backup. And then you got Shizzy. He was on this morning, literally going over his channel, like defending himself. And I thought it was kind of funny because he didn't go over basically all the shit that he used from my channel, just like Megan and J Hip. I was going to talk about Megan attacking this other journalist tonight. She's going after this. I and I apologize. I mean, I hope they don't going to put it. I didn't even. First of all, I never knew who Megan was until this Hale stuff, right? And I did not know who this journalist was either. Um, but I'll talk about it on Saturday, and I'll have more information in regards to it too. But she's starting to harass somebody else and going after her, and I'm like, oh my god! I'm like, I know she has no content, but now you're gonna start ripping apart somebody else, and the hypocrisy. Like she accuses her of the same shit she does to me and us. So anybody that's like anti-Hales that she calls anti-Hales anyway. So it's a whole bunch of hypocrisy. But like Shizzy, like I have Shizzy literally like for months just using transcripts from my live and showing screenshots. There's a screenshot of you and me on the live here. And then he's like showing these body cam things of me. I mean, literally months of it. And as I've told everybody, I never watched him at all, and I rarely got links to him. I don't think many people here watch him, but he's literally using my channel just as much as J Hip is, and it's like, wow, holy crap! And I've had so many like privacy complaints made because they're like doxing me and stuff. So and YouTube has been removing them, and they don't seem to understand why. They keep trying to fight it, but it's not working because they're doing it, and what they're doing is against the guidelines. So, they're really all just, a bunch of, I don't consider these people journalists at all. Megan's the only one that really claims to be one. They're just gossipers and harassers as far as I'm concerned. And they're going to do the same thing with these filings today that they always do. They're going to read one or two lines, stop and pause and ridicule. And it makes it to the point where nobody really gets the gist of what the filing is.
Yeah.
Because they stop, they pause, they stop, they pause. And it's like people tend to believe what they say because nobody's reading the whole thing. Read the whole thing. Huh?
They don't know what's going on. That's the best part. It's like like Tuggle admitted halfway through, I didn't read it, but like that's at least they're idiots. They just don't. That's how they are. They're some of the worst. But whatever. I don't know. I don't know what's going to happen here with this judge. I don't know what these judges are looking to do. I'm happy no matter where it goes. I know what move to make no matter where this thing goes. This thing gets dismissed, great. If it doesn't get dismissed, I got to go to Discovery. Even better. You know how much friggin' content I'm going to get out of this thing? That's what it is. And that's what Volpe doesn't get. It's like, if I'm doing this anyway, I might as well get the content benefit out of it, right?
Yeah. Yeah. I hear ya. Holy crap, it's already 1:45.
Yeah,
wow.
It's late.
Yeah. I know Robbie's actually in the middle of doing something. I'm not sure why he didn't make it, but I'm sure I'll find that out. But Rich, thank you so much for coming on and reading that for me because my eyes are still, I don't know. I must have, Lisa, you've got Shizzy be the no nuts. Yeah, I actually do now. Believe it or not, Shar. But anyway, yeah, so I have something going on. And so I really appreciate you coming on and reading all that. It was very long. Thank you.
No problem.
Hope you didn't wipe yourself out with that. But I'm glad you got to go over your filings today because it would seem very rushed on your show. So at least people.
I had to fight Volpe every paragraph. I think it's still terrible. It's still terrible. Come on.
Yeah.
Oh God.
It was like, all right, like cutting you off and stuff. And that, because people are there to listen to you. They like what you're saying. They like when you're explaining your filings and stuff. And he's trying to like rush you and cut you off. I was like, I'm telling you, I gotta go. I can't watch any more of this. But I did. I stayed the whole time. But and the audience was saying it because they were all getting. And then Michael.
Mike is good though because he grounds stuff. Like because when I get out of control, because I tend to get out of control sometimes, he keeps it grounded. So Mike is good.
Yeah, he's definitely grounding, but he's still got to let you speak. Your point was to show your filings.
Yeah.
And I just thought it was. I'm just gonna say I thought there was a little bit of disrespect there. That's all. So, I know that's just my opinion.
Yeah.
But anyway, I'm glad you were able to go through it tonight, though. And you have this aired on yours, right?
Yeah, it's on
This,
mine right now. It's on my
okay,
YouTube and
cool.
it's on my Substack right now.
Okay, all right, cool, cool, cool,
It's
cool.
on both. And I'll probably do a write up on it like later. I got some write ups to do, but I'll do a write up on this in a day or two. Yeah.
Cool, cool, cool. Well,
Yeah,
thank
like
you
my
again.
tank top. I have my tank top. I'm ready to go to bed. I was like sitting. I'm laying down. I'm like, well, watching this, and I'm like, oh, okay, I'll read. I didn't even get dressed.
Thank you so much. I truly appreciate. I'm sitting here with like one of these like ice rollers that
Mhm.
you can use for your neck or whatever, and I'm like sitting there under my eyes right now. They're
Oh
literally
Christ.
swollen. It's crazy. But anyway, thank you so much, and I hope your test results are good
Yeah, I got to get a
tomorrow.
blood test, and I think it should be okay. It's just I got to see what my blood looks like. But I've been doing my blood. I've been checking it, so it's
Have an
been.
extra glass of water if you drank.
Well, I'm having any booze, but I did my blood sugar it's below 150, so I'm pretty happy with that over the past.
That's good.
Yeah, so I wanted to make sure I got to go and get all that taken care of. So I keep
Right.
my blood sugar below 150. That's where you want to be, and just gonna look at everything. I'm just getting my physical. I got my physical coming up, so I get it now, and then I think after the 4th I go see my doctor. So I got to get the blood test tomorrow.
Well, I hope it's all good for you.
It's good. I'm being good. I'm not pouring myself an old fashioned, or not pouring myself a vodka. I'm gonna actually just go to bed. I poured myself a club soda before, so I'm gonna have finish this club soda and go to sleep.
Right on. Right on. Alrighty, guys. So since it is 1:45, I am going to say goodnight. I'm gonna put some ice on my face, get the swelling down. Rich, again, thank you so much. Post your link in the chat so everybody go check out Rich's
Oh
channel.
yes, everybody has to check out my channel. I'm gonna go to the comments right now. It's at Luthman News. If you haven't subscribed yet, okay, you have to subscribe to Luthman News. Now I have over 500, so I'm working on these creator features and everything else. So I'm going to figure out what the hell they are pretty shortly.
Yeah, they're
But
adding some more features too.
they're
Um,
what?
they're adding some more features that are new that I just noticed recently.
Okay.
Um, so it's actually looking pretty cool.
All right.
Um,
Cool.
so hold on, where am I at here? What? Wrong screen. Wrong screen. Lost you. All right, guys. So anyway, tomorrow night, tomorrow's Friday, right? Right. Yep. We got Get Swamped is tomorrow at 8 o'clock. I will be over there, and then I'll be back on Saturday, and that's when we'll talk about. I'll find out more about this new person that Megan is harassing, and we'll go over that. But hopefully, we'll have some fun on Saturday. Tori will be here with us. Maybe we can get Kendra on. Maybe she's feeling better. Hopefully. And I'll see you guys then. Thank you all so much. Don't forget to leave a comment about what you thought about this video. Um, and that'll be a lot of fun. So prayers out to all you who need it. And for those of you who think you don't, prayers out to everyone. Prayers for Ray. We love you guys. Thank you so much. Have a great night, guys. Bye-bye. Ta-ta. Good night, Rich.
Good night.
Toodaloo.